Morning, everybody.
Morning, Judge.
Morning.
Y'all have any questions? No?
No.
All right, so did they tell y'all it's like 70 minutes on this as opposed to the 50 on the preliminaries for each side?
Say that again. How many minutes?
So it's 70 minutes a side? They're saying they don't think they'll go that long, but it's longer than the preliminaries. I think in the video it said it'd be about 50, but since this is a semifinal round, they're going a little bit longer
Okay.
if they want to take it. Ready?
Got everybody?
Yeah, they just jumped on.
Okay. I'll come back in, sir.
All right, thanks. All right, let's get started, I guess. Props to you guys who went to the office today to do all this. All right, good morning. Are both sides ready to proceed?
Yes, Your Honor. The plaintiff is ready to proceed.
Yes, Your Honor.
All right. Let me call cause number TGCV 001-21, styled Jordan Gilmore as plaintiff versus Chimes Department Stores Incorporated as defendant. We're here today in the 170th District Court in McLennan County, Texas. I've already asked, both sides are ready to proceed. So with that, let's start with pretrial announcements. Plaintiff, do you have any?
Yes, Your Honor. First, may we make introductions before the court?
Sure, go ahead.
Good morning, Your Honor. My name is Zoe Appler, and I'm joined today by my second chair, Ms. Valerie Letko. Today, we represent the plaintiff, Ms. Jordan Gilmore.
Good morning, Your Honor.
Good morning. Defense, do you wish to make an introduction?
Yes, Your Honor. Good morning. My name is Joy Holden, and I'm joined along with my second chair, Nicholas Beachy, who represent the defendant in today's action, Chimes Department Store.
All right, thank you. All right, Ms. Appler, back to you.
Yes, Your Honor. We have a few pretrial matters we'd like to attend to. Would you like to hear housekeeping or substantive motions first?
Let's just go ahead with any housekeeping matters that y'all wish to discuss.
Yes, Your Honor. Now, when laying the foundation to admit an exhibit into evidence today, do you want the witness to have the exhibit available to refer to in front of them, or would you prefer for us to put it up via share screen constructively outside the presence of the jury?
Just go ahead and put it up with the share screen function, and then that way we can all look at it, and we'll take care of it at that point in time and do your objections.
And for objections, Your Honor, would you like us to ask to be heard outside the presence of the jury, or are we always constructively outside the presence of the jury today?
Well, you can ask to be heard depending on where the objections are. I mean, if they're going to be in front of the jury, they're going to be in front of the jury. So if you do have an objection, just raise it. But you don't also have to ask for permission to respond. Just respond after the other side is gone.
Absolutely, Your Honor. Does Your Honor have a preference as to whether we should formally tender any expert witnesses today?
As long as if they're agreed, you don't have to tender them, but in terms of tendering them as experts. So if there's no dispute about that, then go ahead and you should have worked that out, I guess, pre-trial.
Understood, Your Honor. Now, the parties have stipulated to the admission of several exhibits in today's trial. Would you like me to list those exhibits off for Your Honor this morning?
No, just identify them as being previously stipulated to when you're introducing them.
Understood, Your Honor. With that, we have no further housekeeping matters, and we're happy to move on to substantive motions.
All right, defense, any housekeeping matters?
Your Honor, may we assume that witnesses are constructively sworn?
Yes, all witnesses will be sworn prior to trial, so we don't have to go through the steps on that.
Yes, Your Honor, we're ready to proceed with substantive motions as well.
All right. Plaintiff?
Yes, Your Honor. The plaintiff moves to pre-admit Exhibit 14, which is a statement made by agents of our party opponent, Chimes Department Store. Would Your Honor like some further background?
No, is there any objection?
Yes, Your Honor, we have two objections. First, to hearsay within hearsay under Rule 805, and second, as improper character evidence. We don't believe there's been a predicate or any foundation laid for this document to be pre-admitted, and counsel simply needs to lay that foundation in trial.
Okay, well, as it relates to the pre-admission of that document, if there needs to be a predicate for it, then I'll allow the defense their objection and you'll have to admit it. But why don't we at least take up the issue of the hearsay objection at this point in time? So maybe we can save ourselves some time if we're doing that. So what is your response to the hearsay exception?
Yes, Your Honor. This particular exhibit is a recorded statement made by two Chimes employees during their capacity as employees at Chimes. Therefore, it falls under the hearsay exception 8036. This is a record of a regularly conducted business activity.
Okay, so as a business record, you're going to need to have to prove that up. So we'll take that up again when you want to introduce it with the witness. All right, anything else?
No further substantive motions from the plaintiff, Your Honor.
All right, defense?
And none from the defense either, Your Honor. We're ready to proceed with opening statements.
Okay. All right. Let me just get set up 1 second and we'll go from there. All right. Plaintiff, do you wish to make an opening statement?
Yes, Your Honor.
All right, you may begin.
May it please the court. Counsel, members of the jury. Carelessness creates consequences. When people are careless, when they go through life with a disregard for safety, they can hurt others. When a driver gets behind the wheel of a car after having a few drinks, that driver's being careless. They're putting the safety of others in danger. By getting behind that wheel, they're choosing to risk hurting others instead of just paying a few bucks and taking a cab.
Your Honor, apologies. I have an objection here. Permission to be heard outside the presence of the jury.
During opening?
Yes, Your
All right.
Honor. Counsel just compared my client, a department store, to a drunk driver, Your Honor. That's not an issue in this case. That's unfairly prejudicial.
Okay, well, that objection is going to be overruled. I'm sure you can use that during cross or direct to make your points in regards to what was said during opening. Ms. Appler, you may continue.
Members of the jury, you're going to learn today that we're not here because of a careless driver. Not even a careless person, in fact. Today, we're here because of a careless company. Today, you'll learn that the defendant, Chimes Department Store, chose to be careless. You'll learn that Chimes chose their image over their employees, their profits over their people. You'll hear that this company chose to brush problems under the rug, chose to ignore glaring safety issues. And you'll learn that one of their most dedicated employees, Miss Jordan Gilmore, suffered the consequences of their carelessness. You'll learn today that the law has its own word for carelessness, and that's called negligence. Good morning, members of the jury. My name is Zoe Appler, and I'm joined today by my co-counsel, Miss Valerie Letko. And we're here on behalf of the plaintiff, Miss Jordan Gilmore. Now, we're here today because Miss Gilmore suffered an injury while working at Chimes Department Store. And as a result, she's brought this case of negligence against the defendant. You'll hear today that on January 23rd of 2019, Miss Gilmore was injured because of the defendant's negligence. We have to prove that to you today by a preponderance of the evidence. So now I want to take you back to 2009 here in the great state of Texas, in Waco. That's when Miss Gilmore proudly began her job as an employee of Chimes Department Store. And today you're going to get to meet Miss Gilmore. She's going to tell you how she dedicated 10 years of her life to working hard as a clerk for the defendant, how she loved her job, always followed the rules, giving her best day in and day out to be a stand-up employee. You'll also learn that in 2015, the defendant enacted a new policy, a smoke break policy. Now, members of the jury, we all have our vices. And Miss Gilmore will tell you that hers was cigarettes. She was a heavy smoker. And part of her daily routine at work was going out to take a smoke break about once a day. Now, she'll tell you that the defendant's new policy said that all smoke breaks had to be taken out behind the store, near the back door and the dumpster. You'll hear that this policy was put in place to protect the defendant's image. They didn't want customers to see their employees smoking out front or walk through a cloud of cigarette smoke on their way in. So they put their employees out back. A request that might seem reasonable to the average employer. But today you're going to learn what smoking out back really meant for employees. You're going to hear and see these dangerous conditions that the defendant subjected their employees to. You'll see that any employees who wanted a smoke break, including Miss Gilmore, had to stand on this exposed concrete platform behind the store. A platform that was falling apart, without a handrail, without adequate lighting nearby. A platform with chunks missing from it. You'll learn that this was the designated smoke area that the defendants chose for their employees. You'll also learn that the defendant knew that this smoke area was dangerous, that they knew that this smoke area violated building codes, government regulations, and that their owners never inspected it for safety concerns. You'll learn that they were careless. You'll learn exactly what that carelessness meant for employees like Miss Gilmore. You'll hear that on January 23rd of 2019, it's a cold and windy night in Waco. And we all know by 7 p.m. this time of year, the sun's gone. Darkness is hit by 7. And around that time, well, Miss Gilmore and her coworker go outside to take a smoke break. They go out back, just as they're required to do. They open that back door, and they're met with a rush of cold air, a gust of wind. Miss Gilmore ascends the stairs to the ground, choosing to withstand the cold instead of smoking in the doorway, so that the smell and smoke from her cigarette wouldn't sneak into the store. But the stairs and the platform that she could navigate so easily during the day, you'll learn, are much tougher in the dark, because there's no lighting. No street lamps, no exterior lights illuminating that small staircase, only a sliver of light coming through a small opening in the door from inside the storage room. Now, Miss Gilmore quickly smokes her cigarette, then she heads back inside. But as she climbs the stairs of that platform with so little light, no railing to grab onto, she slips. No guardrail to catch her. She falls to the ground, landing on her right leg, damaging her right knee. Miss Gilmore will tell you today that after that fall, she had to have her entire knee replaced. All because the defendant chose not to prioritize the safety of their employees. In fact, you're not only going to hear from Ms. Gilmore today, you're also going to hear from an expert witness, and that's Kelly Danes. You'll meet Mr. Danes today, and he'll tell you he's a mechanical engineer. Mr. Danes will make it clear to you that Chime's department store violated numerous federal guidelines, particularly those governing handrails, governing lighting, governing doors. And the evidence will show you today that that area was dangerous and that the defendant knew that it was. They knew this platform was dangerous. They knew those stairs weren't safe, knew that the lighting was inadequate, but that they didn't do anything about it. You'll learn that they couldn't be bothered to even put a flashlight by the door for their employees. That this area, used not only by smokers, but even by other employees who had to go out and take garbage out to the dumpster or make deliveries, multiple employees had to use this platform, and the defendant put all of them at risk. The evidence will show you that the defendant chose carelessness, chose ignorance over their employees, over safety. And Miss Gilmore, she suffered the consequences of their carelessness. And that's why at the end of today's trial, I'm going to come before you again and ask you to look at the facts, to look at the evidence that you hear today, to apply the law. And I'm going to ask that you find the only verdict supported by the truth. I'll ask you to hold the defendant liable. Thank you.
All right, thank you. Ms. Holden,
Yes, Your Honor.
you may proceed.
May it please the court. Ms. Appler just told you that carelessness creates consequences. And members of the jury, that's true. She told you that the company in charge of that loading dock might have been careless. That's true too. But then she tried to tell you who that was, claimed that the loading dock was the responsibility of Chime's department store. Told you that it was the store's fault. And members of the jury, that's just not true. Because this is a case about choices. Choices that the store couldn't change. You see, Chime's department store is only one store in a whole shopping center. They don't own the building, they rent it. You'll learn that the actual owner, the landlord, is a corporation called Kermit Realty. They chose to build the loading dock where Ms. Gilmore fell. They chose to take responsibility for maintaining it, and when something happens, because of their choices, they're the ones who are accountable. And members of the jury, that matters. Because that landlord, not the store, is the one with the legal duty to repair that loading dock. That landlord, not the store, makes choices about when to fix those stairs. And that landlord, not the store, let those lights go out and let those stairs crumble. So today, the plaintiff is asking you to hold Chime's department store liable for someone else's choices. Choices they just couldn't change. And because the plaintiff today chose to bring this lawsuit, they have what's called a burden of proof. And that means it's the plaintiff's job to convince you four things are more likely than not. First, that the store owner owed Ms. Gilmore a duty. Second, that the store breached that duty. Third, that Ms. Gilmore suffered injuries. And finally, that the breach was the direct and proximate cause of those injuries. And to prove that, members of the jury, we're going to ask you to focus on the three choices Chimes couldn't change. First, the choices of the landlord who owned the building. Second, the inspector who examined it. And finally, the plaintiff. So let's start with the first, the landlord. To understand the choices the landlord made, you're going to hear from the owner of Chimes department store. In fact, Ms. Geller, could you turn on your camera for a moment so that the members of the jury can see you? Ladies and gentlemen, this is Reese Geller. She's the owner of Chimes department store. She'll tell you how Chimes department store is a family business. It was passed down from her grandfather, 3 generations all the way down to her. And for the past decade, Ms. Geller has been responsible for running that small business and serving our community. Thank you, Ms. Geller. You can turn your video off. And Ms. Geller will walk you through the lease that she had with Kermit Realty Group and explain exactly what choices her store can and can't make. You're going to see the parking lot in the front. Chimes is responsible for that. The building, they're responsible for that too. But the alley in the back and the loading dock where Ms. Gilmore got hurt, you're going to hear they were not responsible for that. Kermit Realty is the only one in charge of making that loading dock safe for tenants. That brings us to the second choice Chimes couldn't change, the safety inspector's choices. You'll hear from that safety inspector today, members of the jury. That safety inspector examined Chimes department store and was in charge of telling that store if there was anything they needed to change. You'll learn that when she saw the condition of the loading dock in the back, saw the area that the landlord controlled, she was alarmed. She saw obvious problems back there. But members of the jury, you'll learn that was not what she told the store. Instead of telling them that there were problems, the inspector told Chimes everything is okay. I told them that there was nothing they needed to change. And members of the jury, we're not going to tell you that inspector was right. We think that inspector should have told the store about the problems they saw. And because they didn't, you'll see Chimes had every reason to believe that those stairs were safe. Which brings us to my last point, the plaintiff's choices. Because as Ms. Appler just told you, there are consequences for their choices. We expect the plaintiff to testify today that she's walked up and down those stairs thousands of times before January 23rd. In rain, at night, in all sorts of conditions without a problem. And we expect she'll admit that on that day, something was different. On that day, she chose to walk on the very edge of the stairs, and the evidence will show she didn't have to make that choice. But when she did, there was no way the store could have changed it. And that's why we've raised an affirmative defense of contributory negligence. And that means if we can show you that it's more likely than not that Ms. Gilmore acted unreasonably that evening, and that she didn't exercise the care that an ordinary person would, you can consider her choices in assigning responsibility. So as you listen to the evidence today, I want you to think about what Chimes did and did not have the power to do. Did they have the power to change property they didn't own? Did they have the power to change what the safety inspector chose to tell them? Did they have the power to change the plaintiff's choices? We expect you'll find the answer to those questions is no. The store couldn't change other people's choices. But at the end of this trial, you'll have a choice. And we ask that you'll find the store not liable. Thank you for your time.
All right, thank you. Plaintiff, you may call your first witness.
Plaintiff calls Miss Jordan Gilmore to the stand. May I
All right.
proceed, Your Honor?
May.
Good morning, Miss Gilmore. Can you hear and see me okay?
I can, thank you. Can you hear me okay?
Yes, thank you very much.
Yes.
Would you please introduce yourself to the members of the jury?
Hi there, my name's Jordan Gilmore.
How old are you, Miss Gilmore?
I'm 49,
Where are you from?
born and raised here in Waco.
Do you still live here?
I do,
Do you work here?
not anymore. I did, and I've been unemployed.
Why is that?
I had a bad knee injury when I worked back at Chimes, and by the time I got cleared to go back to work, they said they didn't have a job for me anymore. So I have not been able to find work since. It's been a little rough over the last year.
Now, Miss Gilmore, you mentioned somebody called Chimes. What is Chimes?
Yes, ma'am. Chimes is a local department store. It's not one of the fancy ones like you might have in Dallas or Houston. It's just kind of basic stuff. I think where regular people like me shop.
How long did you work for Chimes?
10 years.
And what was your position?
I was a cashier. I was kind of that face up front when you were wrapping up your business at Chimes.
Now, you mentioned you had an accident at Chimes. When was this?
January 23rd, 2019.
All right, Miss Gilmore, I want to talk to you about that day. Do you remember that day pretty well?
Pretty well.
And were you working that day?
Yes, ma'am.
What shift were you working?
It was the later shift. I'd come in about noon and work until the store closed around 8.
During the course of that shift, did you take any breaks?
Yes, I did. We have what's called a lunch break, even though, it's usually like 4 in the afternoon. And then we had periodic breaks. You could go to the bathroom, you could have a smoke break, and I took some of those.
Did you take any smoke breaks specifically?
Yes, ma'am.
Around what time?
It was towards the end of the shift, I would say about 7 that evening.
Now, where did you take this particular smoke break?
At the only place Chimes allowed us to. There was a loading dock in the back of the store, and Chimes had been very specific that that was where we needed to go for our smoke breaks.
You said that Chimes had been specific about you taking your breaks there. How did they communicate that to you?
A couple of ways. I mean, they told us that, but there was also a memo. I mean, they actually wrote it up and put it, in a memo telling us what we had to do.
Your Honor, permission to publish what's been pre-admitted as Exhibit 1.
May.
Can you see that okay, Miss Gilmore?
Yes, ma'am.
Can you tell the members of the jury what we're looking at here?
Well, this is a memo that came from my manager, Lane Kim. She was the boss when we worked there. And it was, I don't know, 4 years or so before I fell. And this was the official policy we all were told about smoke breaks.
Can you tell us the date on this memo?
July 1st, 2015.
And can you summarize for us what that first paragraph talks about?
Well, apparently the owner had decided they didn't want anybody smoking out in the front of the store where there's that nice wide sidewalk. And so they told us to smoke out back. And I think it says, as you've been told before, if you're going to smoke, you need to smoke out behind the store where our dumpster is. Not only did we smoke out there, but that was the only path to taking out trash and all. And that was the only place we could take smoke breaks on the premises. And of course, we couldn't leave work to go smoke. So,
Retrieving the exhibit. Now, Ms. Gilmore, did you ever take a smoke break out in front of the store?
no, ma'am.
Was this the first time you had taken a smoke break out back?
Well, no, once they told us that the only place we could smoke was out back, that's where all the employees and I took our smoke breaks. So I'd certainly been out there before.
Can you describe the area where you were supposed to take your smoke breaks for us?
Yeah, when you went out the back of the store, there was sort of a double door that opened out onto a rough concrete platform. And then as you went down, there were 3 or 4 concrete steps that led down to the area where you got to the dumpster. So you'd either be on the little platform, on the steps, or you had to walk down the steps to where there was at least a little more room.
Your Honor, permission to publish what's been pre-admitted as Exhibit 19.
You may.
Ms. Gilmore, can you tell us what we're looking at here?
That is the back of the store. You can see the 2 doors I talked about. That concrete platform is what you would walk out onto. Those are the steps, and you can see where the dumpster was.
Retrieving the exhibit. I want to walk us through step by step what happened when you went out on your smoke break that night. First of all, did anyone accompany you?
Yes, one of my coworkers, Riley Huntsberger.
So when you and Riley got outside, what was the weather like?
It was cold. That winter wind was blowing and biting, and it was raw.
Was it dark outside?
Well, yes, ma'am. It's January, and gosh, pretty much all the lights gone by 5:30 or 6. So at 7, it was pitch black. I don't even really remember there being much moon that night.
Well, were there any lights on outside?
No, there weren't. I know you'd think there'd be a light out there, but and there was one, but it wasn't turned on.
You said there was one. Where was this light?
It was up by the door, so it would have lit the platform, but Chimes didn't turn it on.
Your Honor.
Objection, Your Honor, to speculation. May I be heard?
Yes, go ahead.
The witness just said that Chimes didn't turn it on. If I may proffer?
In regards to, you want to proffer some evidence yourself?
Yes, Your Honor.
Okay.
Chimes actually didn't have access to that light. That light was in another department store. So for this witness to say that Chimes didn't turn it on actually is speculative.
May I respond, Your Honor?
Yeah, you don't have to ask permission to respond. Just go ahead and do it.
Your Honor, this is not speculative. This is rationally based on Ms. Gilmore's perception.
All right, so I'm going to overrule the objection. Obviously, it's a question I guess you can take up during cross. All right, you may proceed.
Your Honor, permission to publish what's already been entered as Exhibit 2.
You may.
Now, Ms. Gilmore, is the light that you just referred to the one circled in red on this photo?
Yes, ma'am, it is.
Had you ever seen this light turned on before?
I hadn't.
As an employee of Chimes, were you able to turn it on or off?
No, ma'am, there was not a switch that we could access, or if there was one, I wasn't told about it.
To your knowledge, Ms. Gilmore, where was the switch for this light?
I think it was actually in another store, because we had asked our manager about couldn't we get some light out there if we had to go out there to smoke, and they said no, they just couldn't do anything about it.
Retrieving the exhibit. So, Ms. Gilmore, you go out into that pitch black night. Was there any natural light coming in from anywhere at all?
Well, I mean, those doors open out, and obviously the stores got light. And so we had the door propped open some so that we could see a bit. It was kind of the best we could do under the circumstances.
You said you propped the door open. Did you do that, or did your coworker?
Riley was leaning on the door. You know, those doors pitch. And if with the wind blowing, you're worried they're going to slam shut. So she was leaning on the door. So we had some light. I think she got a little wind block too. So
Now, Miss Gilmore, did you stand in the doorway with Riley?
no, I didn't. I know some people are real sensitive to cigarette smoke, and I didn't want my smoke blowing back in the store. There's also not a ton of room on that platform. So I walked down the steps to that bigger open area.
Now, when you walked down those steps, could you see where you were stepping?
Reasonably well. You know, there were two things. There's some light coming out, and then as you're out in the dark, your eyes adjust some. So I wasn't just going by feel.
Well, was there a railing that you could have held on to help you down?
Gosh, no. There's the wall on the other side, though, and so I had my hand on that so I could, you know, have some balance going down. I don't know if you remember from the picture, those steps are not very even.
Now, Miss Gilmore, you mentioned a lack of a railing. Have you ever seen a railing on that back platform?
No, but I only worked there 10 years. I don't know if there was one before that.
Now, did you make it to the bottom of those steps okay?
Yes, ma'am.
What did you do when you finished smoking then?
I turned around to come back up the stairs.
And did you make it back up the stairs safely?
No, ma'am.
What happened?
As I was going up, my foot slipped on that rough concrete, and I could feel myself going down. You know, that sense you are falling and there's nothing to grab onto and there's nothing you could do. And Riley tried to grab for me and I went down hard.
Okay, I want to walk through that fall moment by moment. Where were you standing in the moment before you fell?
Gosh, it was close to the top.
And how did you slip exactly?
I wish I could tell you for sure. There wasn't anything on the steps, but that surface was, I don't know, I just lost my footing. It's rough, it's narrow, and I was doing the best I could.
Your Honor, permission to publish what's already in evidence, as Exhibit 4.
Okay.
Now, is this the platform that you were on right before you fell?
Yes, ma'am.
So where did you step on this platform to go around the door?
Well, you can see how the door opens out. And so you've got to navigate around it. And that's what I was doing, because when you come up the stairs, you've got to go around that edge to be able to get through the door.
And you mentioned that edge. How much room would you say you had on that landing between the edge and the door?
Gosh, I've really never thought about that distance. 10 inches, 6 inches, a foot. I really don't know. You can kind of see what's there.
Retrieving the exhibit. Now, after you slipped, where did you end up when you fell?
I guess the polite word would be my bum. I landed hard on my backside down on the concrete, down at the bottom.
Prior to landing on your backside, did you try to land on your feet?
Yes, when I could feel myself going, I tried to kind of crouch and land, but the angle was just wrong. I kind of, you know how you try to right yourself, you're trying to land on your feet. So I tried to do that, but it didn't work.
Now, when you landed on your backside, what did you feel?
Twisting pain in my knee. I felt like I was jarred up through my teeth. I hit so hard. It felt like everything was shaken and bruised. My hands hurt.
Objection, Your Honor, relevance, if I may be heard.
The objection is going to be overruled. Witness may continue.
Thank you.
Mark, could you describe what hurt when you hit the ground?
Yeah, certainly my backside, but my knee, my right knee was really painful.
Now, did your coworker Riley ever come and help you?
She did. She did. And at first I told her, no, I can do it. And then I tried to put weight on that knee and she had to help me up.
Did she ever help you get inside?
Yes, ma'am.
Now, after your shift that day, what happened with your knee?
Well, went home, iced it, took some, over the counter, thinking, well, I'd be okay. And the next day it was so painful, I couldn't put any weight on it. So I sought medical care. I saw a bone specialist, an orthopedic doctor, and he told me I literally had damaged my knee so badly I was going to have a knee
Your
replacement.
Honor, both hearsay and under Rule 403 more prejudicial than proven.
Response?
Your Honor, this is not hearsay, as this is a statement of medical diagnosis. The doctor said to her she had to get her knee replaced. And as to 403, it is probative for the jury to hear what happened and what injury Ms. Gilmore suffered. That's part of our prima facie case that we have to establish today.
Your Honor, this is a bifurcated trial. Damages will be considered at a later date. She's already testified that she's been injured. Now she's going into the next day, the next week, her at the doctor, what her doctor is telling her. The jury doesn't need to hear that information to hear that she was injured. She's already testified to that.
Objection will be sustained.
Ms. Gilmore, did you ever speak to any of your managers about what happened that night?
I did. Lane Kim, the same manager who wrote that memo about where we had to go take our smoke breaks.
What did you tell Ms. Kim?
Well, I told her what had happened and what I was going to have to do.
And did Ms. Kim respond?
Yes, she did.
What did she say to you?
Yeah, I guess we should have fixed those stairs, shouldn't we?
Thank you, Ms. Gilmore. I have no further questions, Your Honor.
All right, Cross?
Yes, Your Honor. Good morning, ma'am.
Good morning.
My name is Joy Holden. I've just got a couple of questions for you, okay?
All right.
Those stairs that you just told us about, you've used them thousands of times, right?
Well, I don't know if I'd say thousands. I mean, they were where we smoked and they were where we took out the trash. And we did that many times.
Ma'am, you'd agree with me, you use those stairs about 20 times a week, right?
Approximately.
You'd agree with me there are about 52 weeks in a year, right?
Yes, ma'am, but I didn't work all 52.
Of course, ma'am, you worked most of those weeks, right?
Yes, ma'am.
And you worked at that store for 10 years, right?
Yes, ma'am.
By my math, that's certainly over 1,000 times, right?
I haven't done the math. I'm sure you're right.
So every day you use those stairs, ma'am, you go down to take out trash, right?
If I was taking trash, I would.
You go down those stairs to take a smoke break, right?
Not always, but sometimes.
Because, ma'am, you'd agree with me, you were a pack-a-day smoker, right?
At the time, I've quit now.
So the time that you were working at Chimes department store, you smoked a pack a day, right?
Well, yes, ma'am, but I didn't smoke a pack at Chimes.
Of course, ma'am, but you'd agree with me that most of the days that you were at Chimes, you took a smoke break, right?
I would take a smoke break, yes.
So all the 10 years you worked on those back stairs, they've been the same, right?
I'm sorry, I couldn't hear you.
Of course, ma'am, I said of all the times, the 10 years that you worked at Chimes department store, those back stairs have been the same.
Yes and no. I mean, they'd be different in different weather. They got a little more rugged as the years went along. But if you mean structurally, were they the same configuration? Yes, they were.
That's right, ma'am. And they were. Ma'am, that's a yes?
No, ma'am, I didn't hear you. I'm sorry. There's a little cutout, and so I didn't hear what your question was.
Of course, I'll repeat that again, ma'am.
Thank you.
It's been the same loading dock, right?
Yes, ma'am.
And the same number of lights, right?
Yes, ma'am.
So on the day that you were injured, those things were the same as always, right?
Yes, ma'am.
But what you did was different. Isn't that right?
I'm not sure I know what you mean.
Well, let's take a look at that, Mr. Beachy. Could we have Exhibit 17, please? Your Honor, this has already been entered into evidence. It's fair to say, ma'am, that the staircase there, it has two sides, right?
Yes, it does.
One side is by the wall,
Yes, ma'am.
right? So you can hold on to that wall for balance.
That's right.
It's not possible to fall off of that side, is it?
I don't see how you could.
But that other side, that's away from the wall.
Yes,
You know it's possible to fall off of that side.
it is possible.
Now, when you walked down the stairs that night, you walked along the wall, right?
Yes, ma'am.
You had no problem getting down those stairs.
That's correct.
You didn't fall off then, did you?
No, ma'am, I didn't. I wasn't hurt till later.
But when you went up the stairs, you walked up the other side, right?
I feel like I was more in the center.
Ma'am, when you went up those stairs, you were on the side with the edge. Isn't that right?
No, ma'am, I think I was in the middle. I don't think I was hugging that outside edge.
Ma'am, is it your testimony today you didn't fall off the edge of those stairs?
Well, yes, ma'am, I fell off the edge, but you make it sound like I was walking on that outside edge, and I don't believe that's true.
Let's look at Exhibit 3, ma'am. Mr. Beachy, could you pull this up? Your Honor, this is already pre-admitted in evidence.
Go ahead.
Do you see that, ma'am?
No, ma'am, there's nothing up on my screen.
How about now?
Yes.
You recognize this, don't you?
Yes, ma'am.
This is what that door looked like on the night of January 23rd, right?
That's correct.
This is the part of the stairs that you were trying to walk up, right?
No, ma'am, I was walking up the center. I had to go around the edge of the door when I got to the top, but I wasn't going up the edge of the stairs.
That's right. When you went up the top of those stairs, you had to go around the door, right?
Yes, ma'am, that's how it was designed.
Ma'am, you claim that's how the door was designed?
It opened out, yes.
That's right. That door opened all the way, didn't it?
I think you could open it all the way.
Ma'am, you know you could open that door all the way.
Yes, ma'am.
You chose not to open that door all the way, right?
That's right.
Your Honor, permission to show a demonstrative for the members of the jury. We showed this to opposing counsel. They had no objection.
All right.
Ma'am, this is a diagram of the loading dock, right?
Okay.
You recognize this, don't you?
Well, no, I've never seen it before, but it looks fairly close. I mean,
Well,
I
that's
don't know
right.
if the dimensions are right, but it looks pretty close.
This looks pretty close to what that loading dock looked like on January 23rd, right?
Well, except your steps are even and they sure aren't on the loading dock.
Ma'am, is it your testimony you've never seen this before?
This demonstrative?
Well,
Yes,
this is Exhibit 5. You were shown that in your deposition, weren't you, ma'am?
Oh, okay.
So you do recognize this?
I don't remember it. I believe you if you say I was. That's been kind of a long time, and I don't really remember all the papers you showed me.
But in any case, you can look at it now and tell the members of the jury that this is what it looked like on January 23rd, right?
Subject to what I've already told you about the differences, yeah, I think this is pretty close as a drawing.
So at the bottom there are steps, right?
Yes.
Then there's a door, right?
Yeah, I mean, it's actually two, but
And at the top, you can see that it marks the loading area, right?
you mean where it says landing?
That's right.
Yeah, that's the landing area.
So on January 23rd, to get out on that dock, you had to open the door.
We had to open one of them. Yes, ma'am.
Now on that night, you only opened that door halfway, right?
That's true.
I'm showing you for demonstrative purposes that door opening. You see that, ma'am?
I do.
That's what it looked like on January 23rd, right?
I'm not sure the angle is right, but I agree that door was partway open.
If you're not sure the angle is right, ma'am, let's go back to Exhibit 3. You recognize that, don't you?
I do, but see how it's open a little more? You had it straight on and this is open a little bit more.
In any case, ma'am, that door, that was blocking your way, right?
Partially, not completely.
I'm highlighting a part of that stairs that weren't blocked by the door. You see that, ma'am?
I do.
So on the edge there, that's the part of the stairs that you chose to walk up to get around that door, right?
Yes, ma'am.
So I'd like to talk, ma'am, about you going around that door. You could have opened that door all the way.
I suppose I could have, although that would have required me to be on the stairs balancing opening the door, which you're making sound like wouldn't have been a very good idea.
Ma'am, you had a friend with you, didn't you?
I had a coworker, yes,
You talked about her on direct examination, Riley, right?
I did.
You could have asked Riley to open that door for you, right?
I suppose I could have.
You didn't ask Riley to open that door.
No, ma'am.
You know that there's a double door as well.
On the other side, yes.
You could have asked Riley to open that second double door.
That would not have helped me get around this one, but I guess I could have.
You didn't ask her to do that, did you?
No, ma'am.
Instead, you chose to scoot around that door, right?
Well, yeah, I was wearing tennis shoes. It seemed okay.
That's when you started to lose your balance.
I did.
And when you started to lose your balance, ma'am, your friend, she reached out a hand to help you, right?
She did.
You didn't try to take her hand.
Well, it was happening very quickly. And no, I guess as I was falling off a platform, I didn't catch her hand.
So that's a yes to my question. You didn't even try to grab her hand?
Well, I really don't know if I tried. I was trying not to fall 4 feet to concrete below, so I was doing my best.
Ma'am, instead you jumped, right?
Yeah, I was trying to land evenly on my feet and absorb the load.
I just need a yes or a no to my questions, ma'am, and you jumped off the platform that day.
As I was falling, yes.
You made a choice to jump off those stairs.
As I was falling, yes, I tried to do my best to not be injured.
Chimes department store didn't tell you to jump off that loading dock, did they?
No, ma'am, but they sure told me that was where I had to go smoke in the dark.
Ma'am, that's not what I asked you. That wasn't my question. I asked you if Chimes department store told you to jump off that dock, and they didn't, did they?
No, there was no jump off the dock memo.
A Chimes department store didn't tell you to leave that door halfway open, blocking your way, did they?
No.
And Chimes department store certainly didn't tell you to walk up a few inches of stairs, did they?
Well, there, I guess I disagree. I mean, that is where they told me I had to go. I don't know how you get down there without going on the stairs.
Ma'am, are you telling the members of the jury that Chimes department store told you to leave that door halfway open so that you could walk up a few inches of stairs? That was their direction to you?
I'm not sure we're communicating. Maybe I'm not being clear, and I'm really sorry if I'm not. They told me to use those stairs in that position to smoke. The door being open or not, they didn't say to do that. And no, I mean, it's not like they ever said, walk on that part of the stairs, but that was how it was set up. I don't know what to tell you, ma'am. That was how they set it up. I was doing what they told me.
As you just said, ma'am, a Chime store didn't tell you to jump off those stairs, did they?
No, ma'am.
It was only after you jumped off the side of those stairs that you were injured, right?
Well, I don't think that's quite fair. It was when I fell off the stairs that I was injured.
Ma'am, you agree with me that you jumped off those stairs, yes or no?
I agree. I jumped as I was falling.
And ma'am, you agree with me that it was only after you jumped off those stairs that your knee got hurt, right?
Ma'am, I can't agree with that. I don't think that's a fair description of what happened that night. I just,
Ma'am, you would agree with me that your knee didn't get hurt before you jumped, right?
my knee didn't get hurt before I fell. I agree with that.
It got hurt after, right?
That was the consequence of my falling. Yeah, my knee was hurt.
Thank you, ma'am. Your Honor, nothing further from this witness. Pass the witness.
All right, any redirect?
Briefly, Your Honor. Now, Ms. Gilmore, opposing counsel just talked to you about why you didn't ask your coworker to open that door further. Can you tell us why specifically?
Well, I mean, there are a couple of reasons. It was very cold that night, and we were trying to get back in, and we're in tennis shoes. That's not that difficult to get around. But you gotta remember too, that door opens out. So she would have had to go out and open it all the way or shut it and go past it to get in the other door. I mean, that just all seems so silly. It was cold and dark, and we were just trying to get back in.
Was it windy at all?
Yeah, it was windy. And you got to know, I mean, I don't know if y'all been back there, but the way that wind hits, it's just pulling it in. It's really easy for the wind to catch the door and fling it open. And that sure didn't seem like a good idea.
Finally, Ms. Gilmore, opposing counsel walked you through your fall and your slip. Can you tell us how quickly all of that happened?
Yeah, I mean, this was in a matter of seconds. It was kind of funny listening to her say, you chose, you chose. I don't know if you've ever fallen, but gravity's a real thing. I mean, you fall hard and fast. And this idea that you're sitting there while you're midair making all these choices just seems silly to me. You're falling and you're just doing your best not to be hurt badly. I'm grateful it wasn't more than a total knee replacement, like a broken back.
Thank you, Ms. Gilmore.
Objection, Your Honor. That testimony was sustained from earlier
Your Honor, may I
I'm
respond?
sorry, which testimony was sustained?
about her knee replacement, Your Honor.
Okay, that objection will be overruled.
Your Honor, with that, I have no further questions.
All right. Any recross?
No recross, Your Honor.
All right, may this witness be excused.
Yes, Your Honor.
All right, thank you. Plaintiff, you may call your next witness.
Your Honor, plaintiff calls Mr. Kelly Danes to the stand.
Hi.
Hi there, Mr. Danes. Can you see and hear me okay?
I can. Can you hear me?
Yes, thank you. Your Honor, may I proceed?
You may.
Good morning. Can you please introduce yourself to the members of the jury?
Good morning, everyone. My name is Kelly Danes.
What do you do for a living, Mr. Danes?
So I'm a PE, which just stands for a professional engineer.
And what does that mean?
Well, essentially, it just means that you passed a couple engineering exams. I have a degree in engineering, and that I've worked in the field for at least 4 years.
Now, Mr. Danes, were you hired by my office to review this case and render opinions in this matter?
Yes, ma'am.
Did you come to any?
I did.
How many?
So it's overall, it's just one general opinion. However, there's 3 sub parts of that.
Okay, well, before we get into that opinion, I want the members of the jury to learn about your education and your experiences. Where did
Sure.
you go to college?
So I actually attended the University of Wisconsin-Madison, and I still currently live here in Wisconsin today.
What degree did you get there?
I received my Bachelor's of Science in the field of mechanical engineering.
Did you complete any further education or training?
So I do. I like to keep up to date with the field of engineering as it's constantly changing. I attended various continuing education seminars, but I'm also a certified builder that I received from the Scaffold Training Institute, as well as a certified engineer. And I received that from the American Society of Mechanical Engineers. Apologies.
No problem. Now, are you a registered engineer here in Texas?
Yes, ma'am. That's one of the 7 states that I'm registered in, along with the National Council of Examiners of Engineering and Surveying.
Now, Mr. Danes, where do you currently work?
So I'm the president of Danes Engineering LLC.
And what does your company do?
Essentially, we help to investigate engineering issues in multiple different engineering areas that we've developed a specialty over the years, and we help with people all over the United States.
And how long has your consulting firm been in business?
So my specific consulting firm has been in business for about 10 years now.
Have you ever consulted as an expert witness in court before?
Yes, ma'am. I'd say actually it's the majority of the work that I do, preparing reports, depositions, and testifying here. Consulting on cases specifically like this one with code compliance and things like that. That's a big part of my job.
Now, do you testify more often for plaintiffs or for defendants?
So actually pretty evenly. Plaintiffs and defendants, the amount of times that I've been retained, it really doesn't differ.
Over the course of your career, how many incidents would you say you've investigated?
Ooh, it's a tough one. Probably over 60, I'd say.
How many times have you been deposed?
That's probably about 20 of those.
And how many times have you testified as an expert?
So this is actually my third time here. So I've only been to court twice. So if I'm doing anything wrong, please let me know.
Thank you, Mr. Daines. I want to take a look at today's case. Were you asked to determine whether Chime Department Store's designated smoking area was unreasonably dangerous?
Yes, ma'am. That's exactly what I was asked to do.
So what materials did you review in your investigation?
Sure. So I reviewed some of the depositions here of the plaintiff, Ms. Gilmore, as well as the owner of the department store, Ms. Geller. Additionally, I conducted analysis of the number of OSHA regulations, as well as the IBC statutes that I deal with on a day-to-day basis.
I want to break those down for a second. Can you tell us what OSHA is?
Sure. That stands for the Occupational Safety and Health Administration.
And what does OSHA do?
Essentially, they're a federal agency, and they set regulations for employers and employees to follow in the workplace.
You also mentioned something called the IBC. What is that?
So that's the International Building Code. There's a lot of overlap between that and OSHA. However, these specific safety regulations focus more on the buildings themselves and the codes that follow that.
So are these codes the type of statutes and regulations that you rely on in coming to engineering opinions?
Absolutely. In a case like this where you deal with code compliance, it's going to be always dealing with IBC and OSHA for the majority of times. But here, those are the exact type of statutes that you're going to be dealing with.
Now, did you use any reliable methods during this investigation?
Yes, ma'am. I conducted an on-site inspection of the area, of the designated area, smoking area for Chime's department store. And on top of that, I took pictures of the area and conducted measurements as well.
And is this method standard in your field?
Oh, I would say so. Yes, ma'am.
Did you use and apply reliable principles and methods during your investigation of this case?
Yes, ma'am.
Now, all of that data and materials you relied on, is that the type of information used by experts like yourself to reach conclusions and opinions in a case like this?
Absolutely. Seeing the code and whether or not they comply is going to be exactly what you do for a code compliance case.
And were these facts and data sufficient in helping you come to a conclusion today?
Absolutely.
Did you reach any conclusions to a reasonable degree of scientific certainty?
I did.
Your Honor, at this time, pursuant to Federal Rules 702 and 703, we tender Mr. Daines as an expert in the field of mechanical engineering.
Is there any objection?
None, Your Honor.
All right. He'll be designated as an expert.
Now, Mr. Daines, what is your opinion as to whether Chime's maintenance of their designated smoking area was unreasonably dangerous?
Sure. So their designated smoking area that was located in the back of the Chime's department store, as it was maintained, it was unreasonably dangerous because of its numerous safety hazards in such a small area.
How did you come to that opinion?
Well, like I said earlier, there's probably three main components that came to that, I guess different factors, as you will. And when you look at the totality of all of those factors, again, it showed just how dangerous that area could be for any of the employees.
Now, before we get into those factors, I want to make something very clear here for the members of the jury. Do you consider this designated smoking area to be a loading dock?
No, ma'am, I do not.
Why not?
So when it comes to the classification of an area at issue, it's important to look at not only what the employer labels the area as, but also what the actions of the employer are and its employees. And here, this area wasn't just exclusively used for things like deliveries or it was employees were used this area to throw the store's trash away in the big dumpster, as well as the department store itself mandated that the employees who were to take smoke breaks or to do it in this designated area. So that's why I don't see this as just a loading dock.
Okay, now I want to talk to you about that first component you considered. Are you familiar with the stairs in this designated smoking area?
Yes, ma'am.
Did you inspect those stairs during the course of your investigation?
Yes, as part of my on-site investigation, the stairs was probably one of the first things that I took into account.
Did you take any photos of those stairs?
Absolutely.
I want to take a look at one of those photos. Your Honor, I'm publishing what's already in evidence as Exhibit 6. Apologies, Your Honor. I do believe this is the wrong exhibit. If we can just move forward one slide, Ms. Letko. Actually, we can use Exhibit 18. We'll just use that one. That's fine. Apologies, Your Honor. Can you see that okay?
Yes, ma'am.
Now, did you reach any opinions as to whether these stairs complied with OSHA and IBC standards?
I did. And that opinion would be that these stairs did not meet both of those requirements under OSHA and IBC regulations.
How so?
So these stairs actually were required to have a railing onto the side of them. And as you can see from the picture, there used to be railings, but they have now been removed. Additionally, the concrete on the edges of each one of those stairs have been cracked and worn down, and that just creates a safety hazard.
You mentioned the lack of a railing. How do you know that there is supposed to be a railing on these stairs?
So both OSHA and IBC regulations require that stairways, like the ones that are open here, that have an exposed side to them, need guardrails. And here, those weren't present.
You mentioned the guardrails were removed previously. How do you know that?
Well, you can tell when you look at each one of the corners of it, you can see still parts of the old guardrails as well as where they used to be, the holes from it. So again, we know that they used to be there. However, now and at the time of the incident, they no longer were.
Is that a problem?
Absolutely. Those regulations are put together for a reason. It's in order to prevent this safety hazard and exposing this area to, well, the ground that's right there.
Retrieving the exhibit. I want to move on to the second component that you considered. Was that the back exit doors?
Yes, ma'am.
Did you reach any conclusions about those doors?
I did. And here, when it came to the back exit door, I concluded that it didn't comply specifically with the IBC regulations.
Or did you get a chance to inspect those doors yourself?
Absolutely.
Did you take photos of those doors?
I did.
Your Honor, I'm publishing what's pre-admitted as Exhibit 4. So how did you know that these doors didn't comply with the regulations?
Well, specifically, when the door opens this way, as you see in the picture, that's how it was open at the time of the incident. Well, when it does so, it obstructs the path for the stairs to about a 1 foot space from the edge of that door to the edge of those stairs. And that doesn't comply with what IBC mandates here. And that's going to leave a small space for individuals to walk down.
Why is that a problem?
Well, when you have that small space for individuals to walk down, well, it has the potential for people to fall, unfortunately, like in this case. But specifically, the regulation is put into place in order to make sure that it doesn't take up over 1/2 of the area. And here, not only does it do 1/2, but it goes much further than that. Again, having 1 foot from the area of the door to the edge of the stairs.
And is that safe?
Absolutely not. That's a big safety hazard, restricting the stairways that, again, already don't even have the guardrails to prevent someone from falling.
Retrieving the exhibit. Now, finally, Mr. Daines, I want to talk to you about that last component you considered. Was that related to the lights?
It was. Yes, ma'am. That's the final one.
Did you reach any opinion about whether or not the lighting in that smoking area was safe?
I did, yes. That one here was that it did not comply with the safety of the OSHA standards here.
Now, did you inspect the lighting around that designated smoking area?
I did, yes, ma'am.
Why didn't it comply with those standards?
Well, in order to comply with it, it had to be adequate and appropriate lighting over the area. And here, well, it failed to meet that standard. In fact, it failed to meet it because there was no lighting at all. There was no working light, at least, that came from the exterior of the Chimes building, at least as it covered the back area and the area at incident.
You just said there was no working light. Was there a light fixture on the exterior?
So there was, yes, a little bit above. However, from what I reviewed, it seemed like there was no way for any of the Chimes employees to turn that light on.
So, Mr. Daines, based on your investigation, your training, your experience, were the conditions of this designated smoking area safe?
Absolutely not, ma'am. These conditions included numerous safety hazards and problems in such a small area. Overall, it made this area unreasonably dangerous, not for just Ms. Gilmore, but for all of the Chimes department store employees.
Thank you, Mr. Daines. I have no further questions, Your Honor.
Cross?
Yes, Your Honor. Good morning, Mr. Daines.
Good morning.
I want to start with a couple of things I think we can agree on, all right?
Okay, sounds good to me.
We agree that the stairs behind Chime's department store, they had some issues, right?
Absolutely, I would agree with that.
Let's look at Exhibit 17. Your Honor, this is already in evidence. We agree, sir, that those stairs were crumbling, right?
Yes.
Could we highlight those pipes, please, Mr. Beachy? We agree that whoever removed the railing from those stairs left behind exposed pipes, right?
Exactly, just adding on to the safety hazards present here.
We agree that someone should have fixed that, right?
Absolutely.
But sir, we can also agree that you don't know who was responsible for those stairs, do you?
No, ma'am. It wasn't my job to talk about the responsibility of these issues. However, just whether or not they were in compliance with the statutes, as well as they were even subject to it.
That's right. You can't tell us who was responsible for maintaining those stairs.
No, just whether or not those individuals were subject to the statute at issue, that being OSHA and IBC.
You don't know who should have patched up those holes, do you?
That's correct.
Well, I want to talk now about responsibility, because that question of responsibility, that matters under the law, right?
Oh, absolutely, especially when it comes to these compliance regulations.
Right, because you just told us a lot about those compliance regulations here in Waco, and as a part of your work, you got to read a lot of those rules, right?
That's true. Yes, ma'am.
And so you know that those rules make a distinction between who uses a building and who controls a building, right?
That's correct in terms of OSHA being in charge of the employers as well as the place of employment, whereas the IBC, like I said earlier, focuses more on specifically the building and who controls that.
That's right. Well, sir, I have a hypothetical for you.
Okay.
For example, something like a fire extinguisher, they can keep people safe, right?
Oh, absolutely.
But I can't just go into your house and start putting fire extinguishers on your wall, can I?
Objection, Your Honor, as to relevance.
Your Honor, may I respond?
You may.
This is a hypothetical. The witness just testified that the person who had control over that back dock had responsibility for maintaining it. I'm asking some questions that'll illustrate that for the members of the jury.
Okay. The witness is permitted to answer hypothetical questions, so the objection will be overruled.
So, sir, as you said, those fire extinguishers, they can keep people safe.
Absolutely.
But I can't just go into your house and start putting fire extinguishers on your wall, can I?
No, you wouldn't be subject to any of those requirements at all.
Or if a parking lot has a pothole, that might be dangerous, we can agree.
Oh, absolutely.
But I can't just go around filling potholes in random parking lots, can I?
I mean, no, sure, I'm sure you could, but parking lots get a little bit weird with who's actually in charge of responsibility.
Right, that's because I don't control other people's property, right?
That's correct, yes.
And you can only fix what you're allowed to control.
Yes, under the IBC, I believe if that's what you're getting to, yes, that's correct.
And sir, you know that Chime's department store, they don't own their building, do they?
No, they don't. They're simply just the employer of individuals like Ms. Gilmore.
They rent it, right?
I believe so, yes.
They rent it from a corporate landlord?
Yes, Kermit, I believe is their name.
That's right, a landlord called Kermit Realty, right?
That's correct.
Even though you knew that Kermit Realty owned that building, you never interviewed anyone at Kermit, did you?
No, ma'am. Again, that's not what I was retained to do, just whether or not they were in compliance with the regulations at issue, not to deal with any of this, who was subject to this and that. No.
You never even tried, did you?
No, ma'am. I didn't think it was necessary for this type of analysis. Actually, I think it would be going against what I normally do and what's considered standard in this area.
Sir, you never read Chime's department store's lease, did you?
No, ma'am.
You can't tell the members of the jury if that lease did or didn't include that loading dock, can you?
Again, no, that's not what I was retained to do.
Sir, you'd agree. If Chime's department store wasn't responsible for the loading dock, those standards wouldn't apply.
Not necessarily. For the IBC, yes, because that deals specifically with the building itself and who was in control. But with OSHA regulations, no, because Chimes is an employer, so they're always going to be subject to those regulations.
So let's talk about those OSHA regulations, sir. Those OSHA standards, they have rules for employees as well as employers, don't they?
Absolutely.
Those standards require employees to act safely, right?
Yes, I believe you're talking about 654, and that talks about just like general duty requirements of both the employer as well as the employee.
And they require employees to act responsibly, right?
Absolutely. They're subject to the same standards.
Those rules would apply to Ms. Gilmore, right?
She was an employee at the time, so that's correct.
Thank you, sir. Your Honor, pass the witness.
All right. Any redirect?
No redirect, Your Honor. May Mr. Daines be excused?
All right, thank you. Any objection?
No, Your Honor.
All right. Mr. Daines, you're excused. Thank you very much.
Thank you.
All right. Does the plaintiff have any other witnesses they wish to call at this time?
Your Honor, at this time, the plaintiff rests.
All right. So let's, this would be a good time to stop, and then we'll take a break, say about five minutes, probably end up being about 10, but just 5 minutes, and then we'll come back and we'll have everybody, I guess, begin with any motions, and then the defense will be able to present their case.
Your Honor,
Thank you, Your Honor.
apologies, Your Honor. I'm not sure if Your Honor was keeping time, but we were wondering if we could have a time check if anybody was keeping time, just to see if it matches with our records.
I've got y'all at about 33:54 and defense at 42:12.
Thank you, Your Honor.
All right. Back in 10. All right, with the plaintiff having rested, what says the defense?
Your Honor, we have a motion, if I may be heard.
You may.
We move for a judgment as a matter of law under Rule 50. Even viewing the evidence in the light most favorable to the plaintiff, a reasonable jury could not find for the plaintiff. Today, they had to prove to you the 4 elements of negligence, and they failed in proving the first one, duty. As Your Honor knows, in duty rests control. The plaintiff had to show you today that Chimes department store had control over that area. In fact, what we heard today was the opposite. So we ask that you find for the defense and grant us a judgment as a matter of law.
Thank you. Response?
Yes, Your Honor. Viewing the light in the evidence most favorable to the non-moving party, we have established a prima facie case for negligence today. Specifically, we have established that that duty exists. Now, you heard on the direct examination of Kelly Danes that there was, in fact, a duty owed by this employer to its employees through OSHA, those federal regulations that govern employers. In this case, Chimes department store had a duty to its employees to maintain that loading dock safely, and they didn't do so. They breached that duty, and we showed you today that Ms. Gilmore suffered an injury as a result of that. Therefore, this motion should be denied.
All right. So the defense motion at this time will be denied. You may call your first witness.
Yes, Your Honor, we call Reese Geller.
And you may proceed.
Thank you, Your Honor. Good morning, ma'am. Could
Good
you please
morning.
introduce yourself?
I'm Reese Geller. I'm a native Wacoan, and I live here in Waco.
What do you do for a living, Ms. Geller?
So I am an owner of Chimes department store, and I have been working there for a very long time, but I worked my way from the very bottom up to now being the owner.
What kind of store is Chimes?
So Chimes is a local department store. We sell kind of a broad array of things, some clothing, some appliances, some tools, just kind of your general local store.
And about for how long have you been the owner?
So I've been the owner for 10 years now.
All right, ma'am, I'd like to talk about your building. Is Chimes the only store in your building?
No, there's a store on either side of us, so 2 other stores.
You told us you own the store. Do you also own the building that it's housed in?
I do not. We have, but we don't own the property.
Who owns the property?
Kermit Realty?
Ma'am, do you have a lease with Kermit Realty Group?
Yes.
Your Honor, I'm showing the witness Exhibit 11. This is already in evidence. What are we looking at, ma'am?
This is our lease with Kermit Realty.
So let's take a look at section 1.10, the premises. According to the lease, did you lease out the entire building or just part of it?
Just that part of it that's described there.
How do you know which part you leased?
So there's a map with cross hatching that indicates where we're leasing.
Would you recognize that map if I showed it to you today?
Yes.
Mr. Beachy, if we could get the last page of Exhibit 11. Do you recognize this, ma'am?
I do.
What is that?
So this is the diagram or map, if you will, in the lease that indicates what part of this property we are leasing.
There's a lot going on here, ma'am. Your Honor, may we display this image without the text for demonstrative purposes? We checked this out with opposing counsel. They had no objection.
You may do so.
So let's start by focusing on the bottom half of the map. What's that section with all the lines on it?
So those are parking spaces. That's the parking lot for the whole center.
Under the lease, do you rent out any part of the parking lot?
We rent out that part in the middle.
I'm highlighting the middle in blue. Is that the area that you rent, ma'am?
Yes, that's part of our premises.
What about to the right and to the left of the Chimes parking lot?
We don't lease them, but I don't know if the stores lease them or I don't know anything about their leases.
Let's talk about the top half of the map. What are those rectangles there?
So those are the actual storefronts or stores, and the middle one is Chimes.
I'm highlighting the middle third in blue. Is that the area you rent, ma'am?
Yes,
What about to the right and the left of the Chimes building?
those are the other stores.
What's the area above your building?
That's the alleyway.
Is the alley a part of your lease?
No, it is not.
And the loading dock that we've been talking a lot about today, where is that?
That's in the alley. That's in that red part.
Mr. Beachy, could we get a mark for the loading dock? Ms. Geller, does this mark above the building accurately reflect where the loading dock is?
Yes,
I want to be clear for the members of the jury here, is that loading dock inside or outside of the area that you rented in your lease?
it's outside of our lease premises.
So if the loading dock area was outside of your lease, let's take a look at whose responsibility it was. Mr. Beachy, could we have section 6.1 on the screen? And Ms. Geller, could you read the highlighted portion for the members of the jury?
Use and regulation of common area. The term common area is defined for all purposes of this lease as that part of the shopping center intended for the common use of all tenants, including alleys, loading areas.
So according to that lease, was the loading area behind the building part of your store or a common area?
It's a common area.
Let's get section 6.3 now. Could you read that portion of your lease, ma'am?
Maintenance of common area. Landlord shall be responsible for the good and safe operation, management, and maintenance of the common area.
Based on that section, who did you understand to be responsible for the safety of the common area, like the loading area where the plaintiff got hurt?
Kermit.
Thank you, ma'am. Pass the witness.
Cross?
Yes, Your Honor. Good afternoon, Miss Geller. Can you hear me okay?
Yes,
Right now, you've been at Chimes for over 20 years, right?
yes,
The last 10 of those, you've been the owner.
yes,
Fair to say that as the owner, you want your customers to be safe in your store, right?
of course.
You want your employees to be safe as well.
Absolutely.
But Miss Geller, you yourself don't inspect your store for potential safety issues, do you?
No, because OSHA does that.
Well, you don't inspect the area around your store for safety issues, right?
I think OSHA does that.
Well, let's talk about OSHA for a second. You'd agree that's a federal government agency, right?
Yes,
And the inspections that they do are randomized, aren't they?
I believe so.
You don't get notice before OSHA comes to your business.
I don't think we've ever gotten notice.
So you don't know when OSHA's coming.
Right.
So prior to OSHA coming to your store, you yourself don't perform any inspections of your store, right?
I mean, I walk around the store. I guess I don't know what you're trying to say with inspection.
Miss Geller, you yourself don't inspect your store for safety hazards, right?
Well, I mean, if I were walking in the store and there was a puddle on the ground, I would make sure it got cleaned up. I would clean it up.
But
So-
directing it back to my question, Miss Geller, you yourself do not perform safety hazard inspections of your store, yes or no?
I'm not sure I can answer based on the definition.
Miss
I-
Geller, I'm not looking for you to define safety hazards. I'm just asking. You yourself don't perform a certified safety inspection of your store.
I'm not a certified inspector. I'm definitely not OSHA.
And you don't perform a Chimes inspection level of your store?
Again, I'm just having trouble with that word inspection because I do walk around the store. I mean, I do make sure that, things are going well.
But Ms. Geller, you'd agree with me that the only system that you have in place for safety inspections is your employees reporting them to you, right?
And OSHA.
Okay, Ms. Geller. Now you referred to the platform behind this store as a loading dock, right?
Yes.
Deliveries are dropped off there.
Yes.
Those come almost every day.
Yes.
So you try to keep that area clean and tidy, right?
Yes.
But to your knowledge, nobody besides Chimes uses that area, correct?
I don't stand back there, so I can't tell for sure. I've never seen anyone else use it, but I don't hang out there regularly.
Ms. Geller, nobody besides Chimes employees clean that area, right?
Again, same. I've never seen someone else clean it, but I can't rule out the possibility that they do.
Now, besides being used for deliveries, this area is also where your business keeps its trash, right?
We have sort of a dumpster recycling setup. Yes.
And you yourself ordered that dumpster to be put there, correct?
Yes.
You determined where its location would be?
I suppose in general, where it would be most helpful to the employees.
Your landlord didn't confirm that location, right?
No.
You didn't ask your landlord for permission to bring in that dumpster, did you?
No, I did not.
And your store employees throw away your business's trash into that dumpster, correct?
Yes.
That requires them to go out those back doors
Yes.
and go down those stairs to the dumpster, right?
Yes.
Now, I want to talk to you a little bit about what you and Chimes knew prior to Miss Gilmore's accident. Now, your company maintains employee records, right?
Yes.
These records include workplace injury reports.
Yes.
And Chimes labels these documents as recorded statement guides, right?
Right.
Now, as the owner of this business, you have access to those records, don't you?
Yes.
You'd recognize one of those reports if I showed it to you in court today?
I believe I would.
Directing opposing counsel and the witness's attention to what has been pre-marked as Exhibit 14, and I'm sharing this constructively outside the presence of the jury, Your Honor. Can you see that okay, Ms. Geller?
Yes.
You recognize this, don't you?
I do.
This is a recorded statement guide, isn't it?
Yes.
This report has to do with an injury incident from January 12th of 2010.
Yes, it looks like that's the date.
And you'd agree that records like this one are kept in the course of regular business at Chimes, right?
Yes.
This record was made by someone named April Nardini.
It looks like it.
She was the store manager at the time.
I believe so.
And it was made 4 days after this accident occurred.
Yes, that math adds up.
This accident had to do with another Chimes employee, right?
Yes.
And that was Jason Stiles.
Yes.
Your Honor, oh, apologies, Ms. Geller, this is a fair and accurate copy of that record.
As far as I can tell.
Your Honor, at this time, plaintiff offers Exhibit 14.
Any objection?
Without objection.
It's admitted.
So, Ms. Geller, this is actually an injury report regarding a Chimes employee, right?
Yes.
This report indicates that this incident occurred on January 8th of 2010.
Yes.
Now, directing your attention to the bottom of the page where it says accident loss, I'm going to have my co-counsel blow that section up so you can read it a bit better. Can you see that, Ms. Geller?
Yes.
Now, please read silently as I read aloud. This says, I was out back on the loading dock. My supervisor, April Nardini, asked me to take out some trash and throw it in the dumpster behind the building. It was dark outside when I opened the door and the light wasn't on. So I went back in and asked April where the light switch was. She told me that there was no switch for that light in our store and that the only switch for that light was in the store next door, so there was nothing she could do about it. She told me just to leave the door open and use the light from inside the building so I could see where I was stepping. I did exactly that, but as I was walking down the steps, I slipped on what I think was loose concrete and I fell face first onto the ground at the bottom of the steps. There was nothing for me to grab onto, so I couldn't stop my fall. Did I read that correctly?
Seems yes.
Now, taking a look at the final page of this report, the last item, and if my co-counsel can blow that up for you, this form asks, are there any steps that should be taken by Chimes to help prevent such injuries in the future? That's what it says, right?
Mm-hmm.
And the supervisor who completed this form wrote, make sure there is adequate lighting on the loading dock. Did I read that correctly?
Mm-hmm.
Retrieving the exhibit.
Is that a yes count from the witness?
Yes, Judge.
Okay, and then Counselor, just briefly, we did this outside the presence of the jury in regards to the admission of this document. The last few questions, have those been in front of the jury?
Oh, apologies, Your Honor. Yes.
All right, so you wish to publish that exhibit to the jury then?
Yes, Your Honor.
All right. You make it.
Apologies, Your Honor. So let's talk about what you did in the 9 years between the incident and Miss Gilmore's incident. After this incident in 2010, you didn't install a new outdoor light by those steps, right?
No, we put a light switch to that light.
We'll get to that in a moment, Miss Geller, but you didn't contact your landlord about getting a working light switch for this exterior light, correct?
No, because we put the light switch inside the store, which was our premise.
Well, I'm talking prior to Miss Gilmore's incident. Between 2010 and 2019, you didn't install a light switch.
I think that timeline is correct.
You
We did install the light switch.
We'll talk about the installation you did later, Miss Geller. But first, I'm asking, in that time period, you didn't contact your landlord about getting a working light switch for that exterior light, correct?
I think so, correct.
You didn't put a flashlight by the door for your employees to use when it's dark?
Now, I don't know. I know we keep some things in the back area for the employees, but I couldn't say if we had a light flashlight or not.
You didn't put any reflective tape on those stairs for your employees?
I would have had to ask Kermit for that.
But you didn't?
No.
You didn't send out a memo warning employees about this prior incident, right?
No.
You didn't even post a warning sign about the dangers of those stairs?
Because they're stairs.
But you didn't post a warning sign, correct?
We did not post a warning sign for stairs.
You didn't ask Kermit to post a warning sign?
No.
And you didn't install a hand railing, right?
Right.
Now, Ms. Geller, you claim that it wasn't your duty to make this back exit area safe, right?
Right. Under the lease.
Most notably that the light that you didn't have a switch to control. You say that that wasn't your responsibility.
Well, but we did put the light switch inside the store.
Okay, well, let's talk about that then, Ms. Geller. You'd agree with me, after Miss Gilmore's accident, that's when you finally installed a light switch inside your store, right?
Yes.
Now, you never asked your landlord to repair that broken light outside prior to 2019.
I don't think we had.
And your lease did allow you to make alterations to the inside of your store, correct?
Right.
You'd agree you could have installed that light prior to 2019.
I suppose so.
Thank you. I have no further questions, Your Honor.
Redirect?
You may.
Ma'am, Ms. Appler just asked you on cross-examination about the light switch. She asked you if you asked your landlord about putting that light switch inside your store. Why didn't you have to ask your landlord for permission?
So since the light switch itself was inside our store, it was in the premises that we leased. Under the lease, we didn't have to get permission from Kermit or notify him or anything.
If it was outside of your store, would you have had to ask permission?
Yes.
She also asked you some questions about whether you inspected your store. To your knowledge, are there independent inspections that are done on your store?
Yes, I know that OSHA does fairly regular surprise inspections, and we trust that agency and their inspectors.
Do you get results from those inspections?
I think we only get notified if something is wrong. But yeah, yes, in general, we had not heard that anything was wrong.
Did OSHA ever tell you that something was wrong about your store?
No, absolutely not.
If OSHA told you that you needed to change something, would you have fixed it, ma'am?
Oh, of course. I mean, our employees matter to us.
Thank you. Pass the witness.
Any requests?
Not based on that, Your Honor.
All right, may this witness be excused?
Yes, Your Honor.
All right, thank you, ma'am. Defense, you may call your next witness.
Your Honor, we call Perry Hayden. Hello, Ms. Hayden. Could you please introduce yourself to the members of the jury?
Yeah, my name is Perry Hayden.
What do you do for a living, ma'am?
I'm an inspector for OSHA.
What exactly is OSHA?
OSHA is the Occupational Safety and Health Administration.
What does OSHA do?
So we go to workplaces to inspect them, make sure that they're safe for employees.
How long have you been an OSHA inspector?
13 years.
Did you go to school before working there?
Yes, I did. I assume you mean after high school. So I went to Texas State Technical College. I got 2 separate associate degrees, one in occupational safety compliance technology, and then the second degree in as well. It was an associate's degree also, and that was in environmental technology compliance.
Since starting at OSHA, how many inspections would you say you've done?
Thousands. I couldn't tell you an exact number.
Your Honor, we tender Ms. Hayden as an expert in workplace safety standards.
Any objection?
No objection, Your Honor.
All right, should be tendered as an expert.
I want to shift gears now and talk about this case. Have you ever inspected the Chimes department store in Waco?
Yes, I have.
When was that?
I inspected it in May of 2018.
Do you remember why you were inspecting that store?
Just a routine check-in. Like I said, we go and check workplaces just to make sure they're safe. So it's pretty routine to do that.
To be clear, had OSHA ever gotten complaints from employees at the store?
No.
And when you do OSHA inspections, do you follow a procedure, ma'am?
Yes, yeah, there's definitely a procedure to follow.
What procedure is that?
So, we're going to go in and inspect the area, and then we're going to compare that to the OSHA regulations that exist to make sure that the store, well, in this case, the store, is in compliance.
Is that standard for OSHA inspectors like yourself?
Yeah, it's the same. We would do this at any workplace. Obviously, the type of workplace would change, but same thing. Go and inspect the area, compare it to the OSHA standards.
Have you used that procedure in the thousands of inspections you've done before?
Yeah, that's what I do every single time.
And did you use that procedure when you inspected the Chimes department store?
Yes, I did.
Your Honor, permission to show the witness a map of the area. This is already in evidence.
You may.
Ma'am, does this look like a general layout of the area of the department store?
Yes, it does.
All right, so you go to the department store for that routine inspection. To do that, did you have to go through the parking lot?
Yeah, I mean, I drove there, so I parked in the parking lot, and then I would have walked in to the building through that parking lot.
Did you find any safety issues with the Chimes parking lot?
No, there was no issues with the parking lot.
All right, so did you later go inside, ma'am?
Yes. Yeah, I would have had to go inside to do my full inspection for sure.
Were you able to inspect the inside of the store?
Yes, I was.
Could you describe the inside of the department store for us very briefly?
I mean, I think it's what anybody would think of when they hear department store. You know, has clothes, different items, racks, things hanging. It's a pretty standard department store.
When you inspect inside a store, what are you looking for?
You know, just to make sure that there's nothing out of the ordinary, nothing that's going to be super dangerous for employees, obviously, as well as for customers. But with OSHA, we're really looking to make sure that it's safe for the employees.
As an inspector, do you ever find issues on the inside of retail stores?
Definitely have found issues before. Yeah.
What about Chimes? Did you find any issues inside their store?
No, there were no issues inside the store.
Any tripping hazards?
No,
Lighting problems inside the store?
no, everything looked well lit, easy to see.
Was there anything in that store that worried you at all?
No, nothing inside the store.
So that was inside the store, ma'am. I'd like to talk about what you found outside the store. What about the alley behind the building? Was there anything concerning there?
Yeah, so behind the building, after I went into the store, I went through into the back, and there was, it was alarming. The stairs out back.
What alarmed you about those stairs out back?
They were crumbling, and there was no railing. Just not typical what you would see with stairs that people are using.
Do you consider those to be safety problems, ma'am?
Oh, for sure.
Does Chimes department store own that alley where you saw those safety problems?
No, from what I understand, they do not.
In your understanding, who owns that alley where you saw all of those safety problems?
Kermit Realty, I think is the name.
To be clear, do you know whether Chimes or Kermit Realty was responsible for maintaining that area?
No, I don't know.
Do you know whether Chimes or Kermit Realty was responsible for maintaining those stairs?
No, I don't know.
And do you know whether Chimes or Kermit Realty was responsible for maintaining that light?
No, I also don't know that.
Ma'am, if you didn't know all of that, I'd like to talk about what Chimes did and didn't know. Ma'am, did you ever tell the department store that the loading dock was a safety concern?
No, I didn't.
Did you ever tell them that you'd seen problems?
No, I probably should have.
Did you ever tell them that you were alarmed by what you saw, ma'am?
No, again, I probably should have.
Did you send Chimes any sort of inspection report?
I did send a report.
And in that report, did you tell Chimes that they needed to change anything?
No, I didn't.
Thank you. Your Honor, pass the witness.
Cross?
Yes, Your Honor. Good afternoon, Ms. Hayden. Can you hear me okay?
Yes, I can.
Ms. Hayden, you're a compliance, safety, and health officer for OSHA, right?
Yes, I am.
And that's a federal government agency.
Yes, it is.
And your job is to visit businesses in your designated area to ensure their compliance with OSHA regulations, right?
Yes.
When you visit a business, you determine whether that business is in compliance, correct?
I mean, I inspect it and compare it to the OSHA regulations.
Now, you do these inspections alone, right?
Yeah.
So you alone have that discretion.
Yeah. I mean, it's based off of OSHA's regulations.
Now, Ms. Hayden, as a government employee, you always want to make sure you're doing a thorough inspection, right?
Of course.
A complete inspection.
Yes.
Because as an OSHA employee, you want to ensure safe workplaces for employees, right?
Sorry, you cut out a little bit. Did you say safe workplaces?
I'll ask my question again.
Sorry.
OSHA employee, you want to ensure safe workplaces for employees.
Yeah, of course.
Let's talk about some of your inspection practices then. Now, you'd agree that your experience is with OSHA guidelines, right?
Yeah,
Not any other government agency's guidelines, correct?
no,
Not any other state guidelines.
that's correct.
You haven't been trained in any other safety agency's inspection practices.
I mean, I understand like environmental technology compliance for my degree, but for what I'm doing, I would use OSHA's regulations when I go to a workplace.
So when you do these types of inspections, you're only looking for conditions that violate OSHA's regulations.
Yeah, that's my job.
You'd agree with me, Ms. Hayden. You're a pretty lenient inspector, right?
I'm not sure what you mean.
Well, you're fairly conservative when it comes to issuing citations.
Yeah, I mean, I don't think everything needs to be cited.
This was even an issue with your employer, right?
Yeah,
All right, well then let's talk about your inspection of Chimes department store. The last one you did was on May 5th of 2018, right?
yes.
And prior to that date, it had been a long while since you'd been out there, right?
Yeah, I mean, I go where I'm scheduled to go inspect.
Now you completed this inspection of Chimes alone, didn't you?
Yes, as I've already said, we do our inspections alone.
You completed this inspection during the day,
Yes, it was during the day.
but you also spoke with the manager of the store, Lane Kim, during your inspection, didn't you?
Yes, I did.
And she told you to inspect that back smoking area.
I mean, I asked what areas employees would go, where they would hang out, or where they would have to work or be. So the loading dock would have been told to me as one of those areas.
The manager told you that employees regularly work in that area, didn't she?
I'm not sure of her exact words. That was quite a long time ago, but I was told that employees worked in that area.
And that they take their smoke breaks there.
Yes.
Now, you'd agree with me, Ms. Hayden, it seemed to you like this back area was Chimes' property, right?
No, as I said, I don't know whose property it was. I'm under the impression that it's Kermit Realty's responsibility and their property.
Ms. Hayden, is it your testimony today that that area didn't seem to you to be Chimes' property?
I'm not sure at the time if I thought it was or wasn't. I can tell you sitting here today that would have been Kermit Realty's property.
I'm not asking you what you're saying sitting here today. I'm asking, is it your testimony at the time that you thought it seemed like this back area was Chimes' property? Yes or no?
I've said I don't remember what it seemed like at the time.
Well, Ms. Hayden, you remember being deposed in this case, correct?
Yeah, I do.
You'd recognize your deposition if I were to show it to you in court today?
I'm sure.
Directing opposing counsel, the court, and the witness's attention to Ms. Hayden's deposition. This deposition begins on page 109 of the record, just for the court's reference. Your Honor, permission to show Ms. Hayden her deposition constructively outside the presence of the jury.
You may.
Can you see that okay, Ms. Hayden?
Yes, I can.
Now, this is your deposition, isn't it?
Yes, it is.
As I scroll through here, this looks fair and accurate to you?
Yes.
And getting to the bottom of this page, that's your signature on the last page, right?
Yes, it is.
Now, this deposition was subscribed and sworn to by Guillermo Reyes, right?
That's what it says.
This deposition was taken on August 1st of 2020.
Yes.
And during this deposition, you were told to be thorough, right?
Yeah.
You were told to be complete.
Yes.
And you were asked if there was any additional information you wanted to include that wasn't asked by counsel, right?
I believe so.
Now, directing the witness and the court's attention to page 11 of this deposition, page 119 of the record, lines 4 through 8. Do you see that, Ms. Reyes? Or excuse me,
Yes, I do.
Please read along silently as I read aloud. Question. Do you have any opinion about who was in control of that area behind the chimes, whether it was chimes or the landlord? Answer. Nope. That's way outside my bailiwick. I mean, it certainly seemed to me like it was Chimes' property, or at least that they were in control of it based on everything they told me. Did I read that?
Objection, Your Honor, to relevance. This question was asked. It says, do you know who was in control? She says, no, that's way outside of my bailiwick. And Your Honor, I think that word might mean purview, but certainly the witness answered the question. There's been no contradiction.
Your Honor, may I respond?
You may.
There was a direct contradiction. I asked Miss Hayes here whether or not it seemed to her at the time who was in control. And as you can see in this deposition, she says that it seemed to her that it was Chimes' property, or at least that they were in control of it. That's a direct contradiction to this deposition, Your Honor.
Your
All right.
Honor, when plaintiff
Go ahead.
counsel, apologies, but when plaintiff counsel asked the witness the question, do you have an opinion? She said no. Your Honor, that's exactly what the witness just told you on the stand.
Okay, the objection is going to be overruled. You may continue.
So Miss Hayes, you thought it seemed like they were in control of this area, right?
I guess that's what I said, so sure.
Now, when you first went back to inspect that back area, you were pretty alarmed, weren't you?
Yes, I was.
You saw some pretty obvious issues.
Yes, I did.
Those issues involved the cracked stairs, right?
Yes.
The lack of a guardrail.
Yeah, there wasn't a guardrail, which I mean, later I learned why there wasn't a guardrail, and it makes sense because it's a loading dock and not just used as in and out stairs all the time. But
now, you were so alarmed by these conditions that you did actually mention these concerns to the manager, correct?
so I asked the manager why there wasn't a guardrail, and that's when I learned that it was used as a loading dock, which makes sense. You can't really have a guardrail and have a loading dock because that's not really going to work to bring boxes in and out.
So based on what this Chimes manager told you, you didn't issue a citation.
Because the citation isn't warranted. And as we've heard multiple times today, that was used as a loading dock. It's not just what this one manager told me.
Now, Ms. Hayden, I want to learn a little bit more about how you conducted this inspection. You said you spoke to this manager, correct?
Yes, I did.
But you didn't speak to any other employees.
I'm not required to speak to other employees.
And you didn't.
No, I did not.
You also didn't speak to the owner, right?
Again, not required to. So no, I did not.
You didn't speak to anyone from a company called Kermit Realty, right?
I was not required to speak to anybody from Kermit Realty.
So that's a no.
No.
You didn't inspect this area at night.
No, I do my job during the day generally.
But you did notice that there was an exterior light outside during your inspection, correct?
Yes, I did.
You actually asked the manager about this light?
Yeah, I did.
Your Honor, I'm publishing what's been pre-admitted as Exhibit 2. Can you see that okay, Ms. Hayden?
Yes, I can.
And taking a look at this photo, that light is circled in red, correct?
Yeah, it's circled in red on the screen.
And when you asked the manager about this light, she told you that they always turned this light on when somebody goes out at night, right?
Yes, that was what I was told.
But she didn't turn that light on for you?
It was during the day. That light really wouldn't have changed the bright sun outside here in Texas.
So she didn't turn it on for you to prove that it worked?
No, I didn't need her to.
And based on that information, you didn't inspect this light any further?
No, I didn't inspect the light.
And this is all part of your thorough and complete investigation, right?
Yeah.
Thank you. I have nothing further, Your Honor.
Any redirect?
Yes, Your Honor. Counsel on cross-examination asked you some questions about the lights, ma'am. Did you find the lights to be a problem?
No.
Did you find those stairs to be a problem?
I mean, as I said, they were alarming, but as I was trying to say to the other lady, There wasn't a guardrail there because it was a loading dock. So that wouldn't be an issue, and that wouldn't be a violation of OSHA standards.
Ma'am, you said those stairs were alarming. Did you ever tell Chimes department store that those stairs were alarming?
No, I didn't. And yeah, I did say that they were alarming, and they were. There was issues with them. But as I've said, I didn't tell Chimes about it. I probably should have.
Nothing further.
All right, any requests?
No, Your Honor.
All right, may this witness be excused.
Yes, Your Honor. With that, we rest our case in chief. We ask for a brief 5-minute recess before closing argument.
All right, is there any other motions or anything that needs to be taken up from the plan?
Your Honor, just a time check before we go into closings would be great.
I got you at 11:55. All right, in defense, you've got 26.5 minutes.
Yes, Your Honor. Is now an appropriate time to be heard outside the presence of the jury, or would you rather us wait until after our break?
In regards to?
The jury charge, Your Honor.
Let's actually take that up first before we go on our break, and then we'll go from there in regards to a break, and we'll give you some time for preparing for closing, and then we can have arguments after.
Yes,
All right, so I guess in regards to the jury charge, plaintiff, do you have a submission you'd like the court to take up?
Yes, Your Honor. We'd like to submit jury charge 4.
All right. And defense?
Your Honor, we would like to submit jury charge number 1.
All right. And number 4, I guess why number 4 from the plaintiffs?
Yes, Your Honor. We request jury instruction number 4 as it goes directly to whether or not Chimes department store was negligent. Now, in this case, in order to bring in these affirmative defenses of contributory negligence or a third-party defense, opposing counsel had to meet a prima facie case today to submit that to the jury. And at this point, they haven't laid enough foundation or provided enough evidence to warrant using those 2 instructions. Therefore, we do request that this jury instruction number 4 be used, which goes directly to whether or not Chimes department store alone was liable.
All right, and defense response?
Yes, Your Honor. We request that jury charge number 1 be used. Now, jury charge number 1 includes both the plaintiff's potential negligence and also the third-party landlord, Kermit Realty's negligence. Now, we have met a prima facie case that both of those charges should be submitted to the jury. With regard to the plaintiff's negligence, we heard today that Ms. Gilmore, she walked up those stairs differently than she did any other day. She snuck around those stairs, left the door open when she could have opened it all the way or closed it. We heard that the plaintiff jumped off those stairs herself. That's certainly not ordinary care. Now, with regard to Kermit Realty, we heard that Kermit Realty had a contractual obligation to maintain the safety of that loading dock. We heard that they breached their contract, and that information should be sent to the jury. So on that basis, we would ask that jury instruction number 1 be used.
All right, and is there any response from the plaintiff?
We stand by our previous argument, Your Honor.
All right, the court will use jury charge number 1 for purposes of submitting to the jury and your arguments. Let's take another, let's say 10-minute break, and we'll be back on shortly for closing arguments.
Your Honor, I would like to ask opposing counsel as well. We've also been keeping time on our end, and we were at 16 minutes left. We were wondering if opposing counsel had there's a bit of a discrepancy with time. We've been trying to time both sides if opposing counsel did as well.
That's fine with us.
Okay. All right. So let me ask this again, sorry, before we break, in terms of time checks as to the remainder of the time, plaintiff, do you wish to have a warning, save time for rebuttal?
Yes, I would like to reserve 2 minutes for rebuttal if possible.
Okay. And then with regard to a warning as to when that time's up?
I would, 1 minute would be great.
All right, so at 13 minutes, you would like a warning, correct?
Yes, please.
In defense?
No warnings required for the defense, Your Honor.
All right. Again, with that, we'll take a break and we'll come back. Thank you.
Thank you, Your Honor.
All right, welcome back. Is the plaintiff ready to proceed with closing arguments?
Yes, Your Honor.
All right. Then you may begin.
May it please the court. Counsel, members of the jury. Carelessness creates consequences. When people are careless, when they go through life with a disregard for safety, they can hurt others. But you'll learn that we're not here today because of a careless person. We're here today because of a careless company. Today, you heard that the defendant, Chimes department store, chose to be careless. You learned that Chimes chose their image over their employees, their profits over their people. And that one of their most dedicated employees, Miss Jordan Gilmore, she suffered the consequences of their carelessness. You'll learn that we're here today because Miss Gilmore suffered an injury while working at Chimes department store. You learned that on January 23rd of 2019, Miss Gilmore was injured because of the defendant's negligence. We had to prove that to you today by a preponderance of the evidence. Now you might be asking yourselves, well, what does that even mean? And in a few moments, the Honorable Judge Nowak will come before you. I'll give you a set of instructions. Now, these are your jury instructions. The Honorable Judge will tell you about the questions you have to answer today, what the law really means. Judge Nowak will tell you that today we had to prove to you 3 things in order to prove that the defendant was negligent. The first, that the condition in question posed an unreasonable risk of harm. The second, that Chimes Department Store Incorporated knew, reasonably should have known, of the danger. And third, that Chimes Department Store Incorporated failed to exercise ordinary care to protect Jordan Gilmore from the danger by both failing to adequately warn Jordan Gilmore of the condition and failing to make that condition reasonably safe. Now, that may all sound a bit confusing. So I'm going to break it all down for you piece by piece, step by step, and show you how we proved each of these elements to you today, and how we did it by a preponderance of the evidence. Now, members of the jury, a preponderance of the evidence just means more likely than not, a mere tipping of the scales. So let's talk about how we met our burden today. I want to take you back to the beginning of trial today, when Miss Gilmore took the stand and talked to you about how she started her job at Chimes. She told you that as an employee, she was dedicated. She worked there for 10 years as a cashier, always trying to follow the rules, to give her best day in and day out. Miss Gilmore also told you that in 2015, the defendant enacted that new policy, that smoke break policy. And she talked to you about this memo. She told you that the defendant's new policy said that all smoke breaks had to be taken behind the store near the back door. And that this was done so that customers wouldn't see employees smoking on their way in, that they wouldn't walk through a cloud of smoke. But you heard what smoking out back really meant for Chimes employees. You saw the dangerous conditions that the defendant subjected their employees to. You saw that any employee who wanted a smoke break, including Miss Gilmore, had to stand on that exposed concrete platform behind the store, right next to the dumpster. A platform that was falling apart, without a handrail and without adequate lighting nearby. A platform with chunks missing from it, with pieces of metal sticking out of it. You learned that this was the designated smoking area the defendants chose for their employees. You heard from their owner today, Reese Geller. She told you on cross-examination she never inspected it herself for safety concerns. In fact, the only safety concern she could think of that she looked for in her store was a puddle on the floor. Her exact words were, "Safety stuff isn't really my job." Members of the jury, they were careless. We've met those first two elements. Those conditions posed an unreasonable risk of harm, and the defendant knew it. They knew those conditions were dangerous and they ignored them. So let's talk about some of those conditions. You saw this light that could have been fixed. This light that the defendant knew didn't work, knew was a problem, but that they left alone, with no switch installed when Miss Gilmore was an employee. Miss Gilmore told you when she went outside that night, there were no exterior lights to illuminate that small staircase, only that sliver of light coming through that small opening in the bottom of the door. Miss Gilmore told you when she went out that night, she quickly smoked her cigarette and then she headed back inside. But as she climbed the stairs of that platform with so little light, with no railing to grab onto, she slipped. You saw this tiny bit of concrete, these few inches that she had to navigate around that door. Look closely at this picture, members of the jury. Look at that exposed pipe, the chunks of missing concrete. These were the conditions the defendant left for their employees. So, with no guardrail to catch her, Miss Gilmore falls. She falls to the ground. Opposing counsel wants you to believe she jumped from the platform. But you heard the truth. She fell. And she landed on her right leg, damaging her right knee. And she told you that after the fall, she had to have that knee replaced. All because the defendant chose not to prioritize the safety of their employees. Now, you also heard testimony from an expert witness today, and that was Mr. Daines, Kelly Daines, a mechanical engineer right here in Texas. Now, Mr. Daines' testimony made it clear to you that Chime's department store violated numerous federal guidelines, particularly those that governed handrails, that governed lighting, that governed exposed staircases. The evidence showed you that this area was not safe and that the defendant knew it wasn't safe. They knew this platform was dangerous. They knew that the stairs weren't safe, that the lighting was inadequate. They didn't do anything to fix it. You learn they couldn't be bothered to make this area safe, this area that was used not only by smokers, but by other employees. Any employee instructed to take out the garbage, to help with a delivery, they had to stand in that area. The defendant didn't just put Miss Gilmore at risk. They put all their employees at risk. I want you to remember back to cross-examination today, when the owner, Miss Geller, was on the stand. Members of the jury, she didn't even know what it meant to inspect for hazards. It's no wonder this store was so dangerous. You also heard about that prior incident where yet another employee fell without lights, without a hand railing on that exact same staircase. They let 10 years go by without making a single change. They breached their duty to Miss Gilmore and to all their employees. Their duty to protect them from danger, to make their workplace safe. They violated that duty. And they want you to believe that they didn't even owe their employees a duty, that this landlord, Kermit Realty, did. But you know that's not true because you heard about that new light switch, the one that they installed only after Miss Gilmore's fall, only after she got injured. Remember the words of Lane Kim, her manager. We should have gotten those stairs fixed a long time ago. She didn't say Kermit should have gotten those stairs fixed. She said we should have. We've proven they breached that duty. And that was the third and final element. We've proven that they were negligent. We have met our burden. Now, in a moment, the honorable judge will tell you about the questions that you have to answer today. And he's going to show you this first question. Did the negligence, if any, of those named below proximately cause the occurrence or injury in question? You can see that there are 3 parties listed underneath. And here, members of the jury, you can write yes next to Chimes department stores. You know they caused Miss Gilmore's injury. And you know that Kermit Realty, that Miss Gilmore herself, they didn't. You can write no beside their names. And that means that you have to move on to question number 2. And the honorable judge will tell you that this second question asks, for those found by you to have caused the damages, if any, to Jordan Gilmore, find the percentage caused by, and it lists those same 3 parties. And here, you'll fill in those percentages. Next to Chimes department store, members of the jury, you can write 100%, because you know that that's true. And beside those other 2 parties, you can write 0. The evidence showed you today that the defendant chose carelessness, chose laziness, chose ignorance over their employees and over safety. And that Miss Gilmore, she suffered the consequences of their carelessness. That's why we're asking you to look at the facts, to look at the evidence, and to apply the law and find the only verdict supported by the truth. We ask that you find the defendant liable. Thank you.
All right. Defense, you may proceed.
Thank you, Your Honor. When Ms. Appler was speaking just now, she started her closing argument by saying, we're here today because of a careless company. And ladies and gentlemen, we agree. Actually, you've seen again and again throughout this trial that there is a lot of agreement between the defense and the plaintiff. We agree that the loading area wasn't safe enough. We agree that that condition contributed to Ms. Gilmore's injuries, and we agree that the right party should be held responsible. But members of the jury, what you saw today is that just isn't Chimes department store. And you didn't have to take my word for it, because you saw the lease. The contract between Chimes and their landlord that says explicitly that those loading areas, those are common areas. And common areas are the landlord's responsibility. So when that landlord, when Kermit Realty made choices about the loading area, even dangerous ones that caused Miss Gilmore to get hurt, well, those were choices that the store just couldn't change. But the plaintiff today had the burden of proof to show you otherwise. They had to show you by a preponderance of the evidence that there was a duty, that Chimes breached that duty, that there was injury, and that Chimes' actions were the direct and proximate cause of that injury. But I want to focus here on the choices that Chimes just couldn't change. The choices of the landlord, of the safety inspector, and of the plaintiff. Now let's start with the landlord, because that goes directly to the plaintiff's first element of duty. They had to show you today that Chimes grocery store owed a duty of care to Ms. Gilmore on that loading dock area. And central to that question is duty is control. You'll have the jury instructions to take back with you to deliberations. The judge will instruct you that for Chimes to be liable for this action, they must have control over that area. What that means is that if Chimes didn't have control over the loading dock, they didn't owe a duty of care out there. And you heard from Mr. Daines, the plaintiff's own expert. Even if the safety regulations change depending on who controls that area. And he didn't know who controlled that area. If you don't control something, well, it's not your responsibility. And think about it. That requirement of control, that makes a lot of sense. If someone doesn't control an area, how do you expect them to be able to change it? So say, members of the jury, that you live in an apartment building and the landlord says, well, you take care of your apartment. We'll take care of the pool. Even if you use that pool, you go swimming sometimes, even if you are the only one in your apartment complex who swims, it's still your landlord's responsibility to maintain and clean. That just doesn't change. And that's exactly what happened here. The Chimes was just one tenant in a whole shopping center. They didn't own that building. Their landlord did. And even if they used some portion of it, even if they used the loading dock, they weren't responsible for it. The lease couldn't be clearer, members of the jury. Kermit Realty was. The lease tells us exactly who had control. And members of the jury, I know we talked about this a lot today. We talked to you about control over and over again. I mean, I bet you wish we didn't have to. It's pretty boring reading a lease like this, to talk about common areas, demised premises. But after all of that, we know that the lease says who is responsible. There is a correct answer to this question. There's only one answer to this question, and it's not Chimes department store. That's not what the plaintiff wants you to believe. Well, on cross-examination and closing argument, Ms. Applers argued to you that because Chimes put a light on the inside of their store, that meant that they had control of the outside. But you learned today, members of the jury, that that's consistent with Chimes' lease. Well, they could control the inside of that department store, but Kermit controlled the outside. So let's look at a map from that lease. We know that Chimes oversees their parking lot. That's in blue right there. We know that Chimes oversees their department store. That's also in blue. But what they don't oversee is that loading dock back in red. Members of the jury, we know that Chimes just couldn't control that area. So when Kermit Realty made choices about that area, choices that made it unsafe, those were just choices Chimes couldn't change. That brings us to the safety inspector. As you saw today, the safety inspector came before you and told you all about those OSHA regulations. In fact, I wrote something down that Ms. Appler said in her opening statement. She said they knew their stairs violated building code. That's what Ms. Appler told you in opening statements. But think about the evidence you heard today. Think about what you heard from that OSHA inspector. I asked her, I said, ma'am, did you find those stairs to be a problem? Sure. Did you find that back loading dock area to be a problem? Absolutely. I find it to be alarming. I asked her, ma'am, did you tell Chimes that you were alarmed by that back area? She said, absolutely not. I should have, but I didn't. I said, ma'am, did you tell Chimes that they should have changed something outside? She said, absolutely not, but I should have. Because members of the jury, the evidence today showed that Chimes was acting reasonably. OSHA, the federal agency that deals with inspections, inspected Chimes. That inspector told Chimes, you have nothing to worry about. There's nothing that's unsafe about that back dock, about those stairs, about that light. And members of the jury, when Chimes was looking at that staircase that they don't own, that they aren't responsible for, haven't had an issue with for years and years, it's no wonder why they thought it was safe. The person who was supposed to tell them just didn't do it. That inspector chose not to. And you learn today that safety inspector, she didn't even consider whose responsibility those stairs even were. It's not that the inspector didn't know who owned the building. She told you it was Kermit Realty. It's that she chose not to. And that brings me to my third and final point. The plaintiff's choices. Because it's clear today, members of the jury, that the plaintiff, she just sued the wrong people. She says she's worked at Chimes department store for 10 years. She walked under a sign that said Chimes department store each and every day for 10 years. She didn't walk under a sign that said Kermit Realty Group. She had no idea that she was suing the wrong person. But I want to talk about what she did know. Because on January 23rd, 2019, Jordan Gilmore acted unreasonably when she was outside at night in the dark to smoke cigarettes. She didn't open the door all the way. Instead, she tried to move around the door with just inches of space. She went all the way to the edge of that staircase in the dark, members of the jury. And what's more, she herself, as she was falling, jumped off that staircase and fell to the ground. That's what she told you today. Chimes department store didn't make her do that. It didn't make her choose any of those things. And think about it. For 14 years, multiple employees used those back stairs. Every cashier, every clerk to take out the trash, to receive deliveries, to take smoke breaks. Ms. Gilmore told you herself, and she thought she might have used those back stairs thousands of times over the course of a decade. And on January 23rd, as she's on the same stairs, in the same conditions, with the same lighting that she always is, nothing has changed. But her choices did. And those, ladies and gentlemen, were choices Chimes just couldn't change. These are the jury instructions that you'll have to take with you to deliberation. I want to walk through with you exactly how those jury instructions can reflect the choices that Chimes couldn't change. Taking a look at the first question, the negligence of Chimes department store. You heard today that Chimes didn't have control of that outside loading dock area, that they couldn't have a duty to the plaintiff, which is why we'll ask you to answer that question, no. The last two are the negligence of Kermit Realty Group and the plaintiff, Ms. Gilmore. We're going to ask you to write yes for both of those questions. Why? Because those were choices that Chimes just couldn't change. The choices of the plaintiff to walk up those little parts of stairs, to jump, to fall. And the choices of their landlord. Now that brings us to the next jury question, members of the jury. And this will ask you to assign a percentage of responsibility. Now, because you'll have written no for the first question, we'll ask you to assign 0% to Chimes Realty. We'll ask you to split a 50-50, the percentage between Kermit Realty Group, who had control over that area, and the plaintiff. Members of the jury, this is the last time that I'm going to be able to speak with you. Ms. Appler is going to get the chance to speak with you one more time before you go to deliberation. And I have a question that Ms. Appler needs to answer. A question that Ms. Appler needs to answer in order to prove her case. Because the plaintiff today had to show you duty, they had to show you control. So if Chimes had so much control over that loading dock area, why did they have to ask the landlord to remove the railing? Members of the jury, the answer to that question is because they were required to, because it was in their lease. After hearing all of the evidence today, we ask you to consider the choices Chimes couldn't change. And we ask you to find for the defense. Thank you.
All right, Counselor, you've got 4:17 remaining.
Thank you, Your Honor. Members of the jury, the defense just got up here and they talked to you an awful lot about choices. They talked about Kermit's choices, Miss Gilmore's choices, even the choices of an OSHA officer. But I want you to remember whose choices really matter today, and that's Chimes' choices. Now, they want to point the finger today at everyone and anyone but themselves. So let's talk about one of the places they point the finger, at Kermit Realty, the landlord. They say Kermit had control. But think about that. If Kermit really had control, then why were they able to install that light switch? And even if you think that somehow Kermit had a bit of control, Chimes knew about the dangers that were on their property. And if it was their job to report those dangers to their landlord, well, why didn't they? They still have a duty to protect their employees. And if that's the mechanism they have to use, well, then why didn't they use it? You heard today, when it's convenient for them to fix problems, to get what they want, they can bring in a new dumpster. They can install a new light switch. But when their feet are held to the fire, when they have to answer for their choices, then it's someone else's fault. They blame it on Miss Gilmore. They say that she was jumping around on this platform. You know that's not true. She fell. They can make it out like she's used this platform hundreds of thousands of times and that makes a difference, but it doesn't. Because all it takes is one time to fall. That's why we are here today. Finally, they want to blame this on an OSHA inspector. They say that, just because this inspector didn't issue a citation, they didn't know that anything was wrong. But members of the jury, you know that they did. Someone else had been injured on these stairs, and their own manager told them about this injury. They couldn't give us a straight answer today. They know what they did, and they know what they didn't do. And their expert, this OSHA administrator, this OSHA agent, well, she couldn't give us one either. They bring you this expert to get up here and bend the truth, to tell you that she didn't think that Chime controlled this area when she did her inspection. But members of the jury, you heard her on cross-examination today. She thought that area was owned by Chimes. She thought it was dangerous. Members of the jury, they knew. They knew they had a duty, and they ignored it. And one of their most veteran employees suffered the consequences of that carelessness. Find them liable.
All right, thank you. All right, so we're going to recess now for just a second. I should say I will. I think we're allowed at this point in time to give some constructive feedback, but only about a minute or so for each of our jurors. The other, well, I guess the winner of this round will be going on, and so I think they have a couple of pre-trial matters and things like that for the next round. But in terms of submitting the ballots and then just having a conversation, y'all can just come back on at this point in time, and we'll go from there. I do remind everybody that we are still streaming, so just keep it somewhat light and don't give too much away, I guess, for the final round, one way or the other, so that we can get a good round on the final. Let me just make sure. I know if our jurors want to go ahead and take themselves off of it on the video. All right. So I'm gonna, like I said, I'm gonna step away for just a second, make sure we got everything going, and then y'all will handle that while I'm gone, and we'll be back on. Thanks.
You want me to start? Does one of us need to start?
One of us needs to start.
I'll do it. I'll be the starter. You both were outstanding, and we were told to say one thing and not say anything nice because we don't have enough time. So just know I'm not saying a bunch of nice things because we don't have time. Zoe, the one thing that caught me was when you were crossing Ms. Geller and you were dealing with asking her about whether she did inspections. She got hung up on that as a technical word. And I think you can do that in another way, like maybe a short list of things she didn't do that are tasks that are not technical. And you can achieve the same thing. Okay. And not get sort of in like kind of an argument with her. Joy, I love your delivery. You make me want to listen real carefully. I would, though, you have a passionate delivery and it really does make you want to listen, but you have this, you tend to use the same tone, even with sort of like ministerial things, like background and that kind of thing. So I would maybe make that a little bit less, I don't want to use the word emotional because you're not emotional, but I think you understand what I'm saying, and save your amazing delivery and sort of listen to me demeanor for the points that you really want us to listen to. And I think that would be outstanding. That's all I have.
I guess I'll go second, because actually I want to emphasize what Libby just said, which was the really one point I thought for both of y'all. There was so much emphasis on every single word and every single sentence and every single question, that not only did it take away from what was really important, as Libby mentioned, but as a juror, it actually gets kind of exhausting to listen to. And so I think it takes away from your overall effectiveness. It's okay to just sort of talk like a normal person for significant parts of your examination. I think that gets lost in the fact that because it's a presentation competition and it's about your presentation, that you tend to emphasize and focus on everything, but that actually, I think, takes away from the overall performance. The one other thing I'm going to say is both of you can do a little bit better to engage in the other side's case along the way, to talk about facts in the case that are going to be important for a closing argument, that is going to rebut the other side's arguments that they are making. Y'all kind of stuck in your lanes, very much, and talked about the evidence that you wanted to talk about for your case. I think you can both enhance your presentations by listening to what the other side is doing and addressing it along the way, so that you've got some real ammunition to make arguments in closing that directly address the other side's case, more so than you did in your presentations today. But excellent job overall. Thank you.
Andrew, you have something you want to say? You want me to jump in?
I think I'm supposed to let my former professor go first. So you first.
All right. Well, let me just say, I think that some of the things we're pointing out are certainly made more challenging by the fact that we're doing this by Zoom. I think it's far easier to have it come off a little more natural and real when you're with people in the same room instead of talking to a screen. So please know that we appreciate the difficult circumstances that you both were in and doing things in this way and dealing with witnesses in the same way and all of that. I think that you both did a remarkable job. I would say when everything is dramatic, then nothing is dramatic. When you're trying to emphasize points, there has to be some variation, some things that are more casual, some things that are emphasized more greatly. And so that would be something I would do. I'd also suggest too that when you're, especially Joy, when you're on the defense side representing a company, and your witnesses come up and they're your witnesses, to call them all ma'am continues to kind of keep them at a distance and doesn't really humanize them in a way. So make sure that in all of those subtle ways too, with the way that, as Joel and Libby have already said, dealing with the evidence and that sort of thing, you want it to be natural. Also, you want there to be a natural rapport with your witnesses, and that's hard to do when you haven't met them and they're on a screen and all those kinds of things. But just always remember how important it is to have a really great rapport, particularly with your own witnesses, and then being very polite with even those that are not. But I mean, I think that you've done a great job. Congratulations.
Agree completely that you guys have done a great job, and kind of echo the comments of everyone else. The one thing that I would put on top of that is I think you both noticed that cross-examination can be dangerous. And I think that you both kind of committed some of the same stylistic violations that make it more dangerous. Just remember, you don't want the witness to have to answer the ultimate question, because they're not going to. You want the witness to admit facts, and then you make statements about what those facts show as part of your argument. And you also want to limit your questions to kind of one fact per question without a lot of lead in or a lot of emphasis. So, try to think about that, particularly with the experts. Ms. Appler, you kind of had some issues with the other side's expert when your questions would get a little bit longer and she would fight back. If that happens, one other thing to think about too is, we talk about it, like when I talk with our associates, it's don't accept the dodge. If a witness gives you a dodge of a question, like when the witness says, well, I didn't speak to so-and-so because I wasn't required to, don't accept that. That's a nonsense answer. Don't let her get away with that. Well, you were then use that word again and repeat it back to her. You're required to do the best inspection you possibly could. You're required to reach the right answer. You're required to do everything to make sure that the employees were safe. Throw all of that right back at her. But the way to avoid getting any of the dodge in the first place is just make her answer the fact question. You didn't interview X person, and if you did that with her, I think you'd have a better chance. And Ms. Holden, you had the same issue with the other side's expert, the OSHA expert. He didn't really want to talk to you too much about whose responsibility it was for control when your whole defense was control. I mean, you might have just had a one question cross from, excuse me, you don't know whether or not it was their responsibility to control this, right? Yep, that's all I got, thanks, and then just be done. It's a weird case that you have to try because control is a legal issue. And so, arguing it from the defense is really difficult, but I thought you did a good job with that. And Ms. Appler, I thought you did a really good job with pointing out, well, they had all these prior incidences of control, why couldn't they control it now? So congratulations to both of you for doing a really, really great job.
Did everybody get their chance to talk? Okay.
I want to say one thing. You both have beautiful smiles, which I didn't really see during the trial. Ms. Holden, there's got to be some opportunity to smile, like maybe with your witnesses. I think you guys can find place for that.
All right, we can actually kind of keep talking just a little bit until we get the results back. So they're going to come in here and let me know shortly, and we'll announce that. I just thank y'all again. This is always fun for us to come and see y'all be much better lawyers than we'll ever be. That's kind of why I became a judge. I wasn't so great at lawyering. I have one of my law school classmates here, one of my law professors here. So, they'll tell you I'm not lying about that stuff. As it stands, y'all did a great job. Thank y'all again for that. My only tips will be Ms. Appler. In terms of cross, I think what Mr. Ryan was saying, I'd echo. I would just tell you to speed that up a little bit. Don't give them the opportunity to respond. Keep your questions relatively quick. No matter the case, it's all a show for the jury. So on cross, you got to be a little bit, more of the TV lawyer, not letting them kind of control the pace of the questions. You got to be kind of quick and move it along. Jury's not going to remember, all but maybe one or two things that happen anyway. And Ms. Holden, I would have liked to have seen you object a little bit more. The one piece of evidence that came in, that was the prior accident that occurred that they got in through, I think, your witness. That there's ample opportunity at least there to object. The judge might let it in anyway, but at least fight it for at least purposes here. Unless you made a calculated decision, it just seemed like something that wasn't going to help your case in any way, shape, or form. And if that's the case, then you keep it out with some kind of objection. But again, we're not going to sit here and give y'all kudos left and right, because y'all certainly deserve them. We just don't probably have the time to do that. But if y'all have anything else from our jurors to add in, again, quick hits before they come in with the verdict, then feel free.
You should shame that lady for being a smoker if you're the defense. I was so surprised that never came up. Honestly, she could have smoked in her car. She didn't have to take a smoke break. She's I have a lot of smokers in my family, both my parents, siblings, but you should have shamed her for being a smoker. There's a reason why personal responsibility won all those tobacco trials until the people that built Baylor Law School made enough money by proving it was actually addictive. But there's a reason why personal responsibility is a good defense theme in the tobacco case, and you should have used it here.
Yeah, I thought there was a lot of emphasis on the light, and I wasn't really sure. I get that it goes to control, but ultimately, the light is not what made her fall. I thought both sides could have emphasized a lot more on, why did she open that door instead of the other door? Isn't that the natural one? And on the plaintiff side, really punishing the store for making this about somebody else. To me, this whole idea of them not being in control is a lawyer argument made up for the fact that a jury is going to have a really tough time with. And you show that by saying, so where's the evidence that y'all asked the landlord to do anything about it? Where's the sign that you put on next to the door that told your employees, be careful when you go outside, because we tried to get the landlord to fix this and they haven't done it yet. So, there are just sort of some common sense things that if I felt like if the store really, was trying to do right by their employees in here, that they would have done, that weren't present. And that's where I think you can, paint the defense of control as one that is trying to pass the buck and not a legitimate issue of, does somebody else really take the primary responsibility for this accident? And correspondingly on the defense, I think you really need to be cautious in building what's the value statement. Why is somebody else responsible? Why has the employer really lived up to what it can and should do? Because there's a potential really, really damning argument that really didn't get fleshed out all the way. I think on the factors that really matter that caused this fall. So.
Anybody else? I'll add that I think on the defense side of things, you can twist it a little bit in some respects on the responsibility of the plaintiff in this case. To get her to describe how she had to get around that door. She's tiptoeing around the door, swinging around it, whatever, all because she's so desperate to have that cigarette break, that may be something to explore. And then, on the plaintiff side, I think just in terms of attacking the ridiculousness from the defense side is a little bit something that's kind of left on the table. Go for it. Go crazy. Jurors love it. All right, so here we go. All right, the winner, have the jury verdict as it were right now. It is a judgment in favor of the plaintiff. Ms. Appler, you'll be going on. They've asked me to tell you to stay in the room. Congratulations. They'll be discussing some, I guess, preliminary issues with you for the final round. Ms. Holden, great job. Making it as far is pretty amazing anyway. So head held high, and we look forward to seeing both of y'all in court in the near future. So thank y'all very much, and we appreciate your time.
Congrats, Zoe.
Yeah.
Thank you so much, and thank you all for such a great round. We super appreciate you taking the time, and thank you, Joy, for another great round. It was so wonderful to compete against you.
All right. I guess everybody else is excused. Again, we're still streaming, so I don't know how they're doing all that. At least it shows it is for me here. They're telling me that maybe that's not the case, but Ms. Appler, if you'll just hang out, and like I said, they'll come back and talk to you. It was great seeing everybody.
Great to see you.
Thank
too.
Great seeing you, Judge. Good luck, Miss Appler.
Good luck.
Good luck.
Bye-bye.
Hey, Zoe.
Hey.
Just real quick, have you played, so in the other round, it's Carolyn and Jenna. Have you played either one of them already?
Yes, I played Jenna.
Okay, you played Jenna, all right. So I'll come back in a second, and depending on what the outcome is over there, then either we'll flip a coin. If it's Carolyn, if it's Jenna, then you'll be sidelocked.
Yeah.
Okay, I'll be back in a second.
Okay, sounds good.
All right, Zoe.
Hey there.
Hey, so it is Jenna Forster, and so you are side locked, so you'll be the plaintiff in the final round.
Okay.
It will be in court. I'll get you your witness contact info here shortly. It'll be in courtroom 1.
Okay.
So that the same Zoom link that would have been taking you there earlier this morning would take you there next afternoon. Woodshedding will start at 2, so 1 hour before the trial, just like this morning.
Okay.
And then the round will be at 3 p.m. Central Standard Time. So we're on the same time zone. So nothing else changes. No change to pretrial order. So same deal.
Okay.
All right. Well, congratulations, and we'll see you here in a little while.
Thanks so much.
All right.